All rise. Veuillez vous lever.
Please be seated.
The Seabed Dispute Chamber of the International Tribunal of the Sea is now in session. L'audience de la Chambre pour le règlement des différends relatifs aux fonds marins du Tribunal international du droit de la mer est ouverte.
Good morning. The Seabed Disputes Chamber of the Tribunal meets today pursuant to Articles 26 and 40 of the Statute of the Tribunal to hear the parties' oral arguments in two cases, namely, the case concerning an inquiry by the International Seabed Authority between Nauru Ocean Resources, Inc. and the Authority Provisional Measures, and the case concerning an inquiry by the Authority between Tonga Offshore Mining Limited and the Authority Provisional Measures. On June 5th, 2026, Nauru Ocean Resources, Inc. and Tonga Offshore Mining Limited each submitted an application instituting proceedings before the Seabed Disputes Chamber against the authority, and these applications were then entered into the list as case 34 and 35. The application in each case was accompanied by a request for the prescription of provisional measures under Article 290, Para 1 of the United Nations Convention on the Law of the Sea. I would like to take this opportunity to highlight the historic nature of these proceedings. It is the first time that the Seabed Disputes Chamber is seized with contentious cases, and also the first time that cases are submitted to the Chamber by entities other than state parties. I now call on the Register to summarize the procedure in the cases and to read out the submissions of the parties. Registrar.
Thank you, Mr. President. On 5th June 2026, copies of the two requests for the prescription of provisional measures were transmitted to the authority. By orders of 10 June 2026, the President of the Seabed Disputes Chamber fixed 2nd July 2026 as the date for the opening of the hearing. As agreed during the consultations held by the President of the Chamber with the representatives of the parties on 9 June 2026, the authority filed on 25th June 2026 a single statement in response regarding the two requests. I will now read out the submissions of the parties. In case number 34, the applicant requests at paragraph 70 of its requests for the prescription of provisional measures that the Seabed Disputes Chamber prescribed the following provisional measures. I quote, A, order the authority to immediately suspend the inquiry regarding the alleged possible non-compliance of NORI with its contractual obligations pending the final decision of the Chamber. B, order the authority to refrain from taking, authorizing, or permitting any further steps or measures in connection with that inquiry pending the final decision of the Chamber. C, order the authority to ensure that no recommendations, findings, reports, or other outputs arising from the Legal and Technical Commission's inquiry are adopted, issued, published, communicated, or otherwise relied upon pending the final decision of the Chamber. D, pending the final decision of the Chamber, prohibit the authority from taking any step or adopting any position, including through the Legal and Technical Commission, that would have the effect of prejudging, refusing, or otherwise adversely affecting NORI's application dated 19 January 2026 for an extension of the exploration contract insofar as such action is based on or influenced by the ongoing inquiry. For the avoidance of doubt, this measure does not prevent the authority or the Legal and Technical Commission from proceeding with consideration of that application in a lawful and impartial manner. E. Prohibit the authority from taking any action that might aggravate or extend the dispute, prejudice the execution of any decision, the Chamber may render, and F. Order such other provisional measures as the Chamber considers necessary to preserve NORI's rights and to ensure the effectiveness of its eventual decision. End of quote. In case number 35, the applicant requests at paragraph 65 of its request for the prescription of provisional measures that the Seabed Disputes Chamber prescribed the following provisional measures. I quote, A, order the authority to immediately suspend the inquiry regarding the alleged possible non-compliance of TOML with its contractual obligations pending the final decision of the Chamber. B, order the authority to refrain from taking, authorizing, or permitting any further steps or measures in connection with that inquiry pending the final decision of the Chamber. C, order the authority to ensure that no recommendations, findings, reports, or other outputs arising from the Legal and Technical Commission's inquiry are adopted, issued, published, communicated, the dispute, or prejudice the execution of any decision the Chamber may render, and E, order such provisional measures as the Chamber considers necessary to preserve TOML's rights and to ensure the effectiveness of its eventual decision. End of quote. The respondent, at paragraph 97 of its statement in response, requests the Seabed Disputes Chamber, I quote, A, to considers necessary to preserve TOML's rights and to ensure the effectiveness of its eventual decision. End of quote. The respondent, at paragraph 97 of its statement in response, requests the Seabed Disputes Chamber, I quote, A, to reject all of the requests made by NORI and TOML for the prescription of provisional measures, and B, to order NORI and TOML to bear in equal share the authorities' costs of responding to their requests for the prescription of provisional measures and attending the hearings in Hamburg on 2nd and 3rd July 2026. End of quote. In a letter dated 10 June 2026 and received by the Registry on 15 June 2026, the non-resident permanent representative of Nauru to the International Seabed Authority stated, and I quote, Nauru as NORI's sponsoring state hereby gives notice of its intention to submit written and oral statements in relation to NORI's application, including in respect of NORI's additional request for the prescription of provisional measures under Article 290, paragraph 1 of ITLOS. End of quote. Pursuant to Article 190, paragraph 1 of the Convention, the Chamber has decided to invite Nauru as the sponsoring state to participate in the oral proceedings on the request for the prescription of provisional measures by making a 30-minute statement on 2nd July 2026, that is today. An additional speaking time of 30 minutes will be allocated to the authority on 3rd July 2026. Mr. President.
Thank you, Madam. Following the above-mentioned consultations held on the 9th June 2026, and in the light of the agreement of the parties, this is a joint hearing of the two requests for the prescription of provisional measures submitted by the applicants. At today's hearing, the parties will present the first round of their oral arguments. The applicants will make their arguments this morning from 9:30 until approximately 1:15, with a 15-minute break at around 11 a.m. The respondent will present its arguments this afternoon from 2:45 p.m. until approximately 6:30 p.m., with a 15-minute break around 4:15. The sponsoring state, Nauru, will make its oral statement thereafter. Tomorrow, the parties will present the second round of their oral arguments. The applicants will speak from 10 a.m. to 11:30 a.m. The respondent will speak from 2 p.m. to 4 p.m. I now call upon the agent of the applicant, Mr. Nathan Eastwood, to introduce the delegation of the applications. You have the floor, sir.
Mr. President, members of the Chamber, my name is Nathan Eastwood, and it is an honour to appear before you as agent on behalf of Nauru Ocean Resources Incorporated, or NORI, and Tonga Offshore Mining Limited, or TOML. I present the members of the applicant's team. To my right, I have Mr. Samuel Wordsworth, KC, Counsel and Advocate. To his right is Miss Amy Sander, KC, Counsel and Advocate. To her right is Mr. Sean Augie, Counsel and Advocate. In the second row, I have Miss Yulia Samsonova, Counsel. To her right is Mr. Michael Lodge, Legal Consultant. And behind them is Mr. Corey McLaughlin, Applicant's Representative, and Mr. Ryan Coombs, Applicant's Representative. These are the members of the applicant's team in attendance before the Chamber this morning. I thank you.
I now call upon the agent of the authority, Mr. Stephen Dittrich, to introduce the delegation of the authority. You have the floor, sir.
Mr. President, esteemed members of the Seabed Disputes Chamber, it is truly an honor to stand before you today as agent for the International Seabed Authority. I am Stephen Dietrich, Legal Counsel and Director of Legal Affairs at the International Seabed Authority. Today I'm joined by my esteemed colleague, Ms. Gwen Legrun and Matteo Bedendi in the second bench over here to my left, as well as our external legal counsel, Professor Philippe Sands, King's Counsel, alongside Mr. Remy Reinhold and Ms. Lucy Jones. Thank you.
I thank the agent of the authority. We will now hear the first round of the applicant's oral arguments. I give the floor to Mr. Sam Wordsworth to make his statement. You have the floor, sir.
Mr. President, members of the Chamber, it is an honour to appear before you on behalf of the two applicants in these proceedings, Nauru Ocean Resources Inc. and Tonga Offshore Mining Limited, referred to as NORI and TOML. We note the historic nature of this occasion. The purpose of the current request for provisional measures is a simple one: ensuring that the applicant's right to due process is respected pending this Chamber's final decision on the two substantive applications that were lodged on 30th May 2026. And of course, a key part of the final relief sought in these two applications is that the respondent should not prejudge or decide upon issues of alleged non-compliance by NORI and TOML unless and until the procedural requirements of due process, transparency and fairness have been satisfied. If the interim relief is not granted, the final relief sought is at very real risk of being rendered illusory. As the Chamber will be aware, pursuant to the exploration contracts entered into with the International Seabed Authority, each applicant has been granted an exclusive right to explore a defined part of the area, that is, the seabed and ocean floor and subsoil thereof, beyond the limits of national jurisdiction. And naturally, those contracts set out certain obligations binding on the applicants. It is not in dispute that the Legal and Technical Commission and the Council of the Authority play a central and important role in monitoring and assessing the applicant's compliance with those contractual obligations. It is similarly not in dispute that the Commission, in its supporting role to the Council, can pose questions to the applicants, make inquiries regarding their compliance with those contractual obligations. It is not the case, as asserted by the respondent in its written statement of 25th June, that the applicants claim that the authority is not even permitted to put any questions to them about their activities. Not at all. What the applicants do say is that in the course of such inquiries, at every stage, the applicants have a right to due process that must be respected. The applicant's right to due process is a position on which Nauru, the sponsoring state of NORI, and Tonga, the sponsoring state of TOML, have expressed their full support. As will be explained in further detail, it cannot seriously be denied that the applicants have a plausible right to due process in this regard. The authority's obligation to ensure due process while assessing a contractor's possible non-compliance is expressly recognised by the authority's own documents. Indeed, the Council decision of 19th March 2016 expressly provides that in pursuing the inquiry into the applicant's conduct, the Commission is to ensure due process, transparency and fairness at every stage, including by providing contractors with the right to respond. As to what due process requires in the current case, the applicant's position is a modest and pragmatic one. They do not seek to dictate how and on what terms the authority carries out its mandate, as the respondent has suggested in its 25th June statement. Rather, it is the applicant's position that first, they have a right to understand the legal and factual basis for their identification on 6th March in respect of possible non-compliance, and likewise for the questions put to them by the Commission on 16th March. And second, relatedly, they have a right to an opportunity to respond meaningfully to clarified questions. And clearly that opportunity must be afforded to them before any finding, statement, or indeed recommendation is made by the Commission with respect to alleged non-compliance. In essence, the applicant's position is that the authority should explain its specific concerns, including the legal basis for those concerns, and also identify the procedural path forward, thus ensuring due process and an opportunity for meaningful engagement in good faith. It is not such a big ask, and one might wonder why the Chamber is having to be troubled with this. Whilst the respondent has sought to characterise the applicants as having, and I quote, steadfastly refused to provide any substantive response to the questions sent by the Commission on 16th March 2026, that is an obvious mischaracterisation. Rather, the applicants wish to be put in a position where they can respond meaningfully. And their position is that in order to ensure that their responses are provided on an informed basis and in a meaningful way, as well as pursuant to a transparent process, the authority must adhere to the two key due process requirements that I've just referred to. Regrettably, those due process requirements have not been adhered to in the authority's treatment of the applicants to date, although this could have been achieved so readily including by releasing the pressure valve of the 31st May deadline for responding to the questions put by the Commission. The key events can be summarised in 3 stages, and Mosanda will shortly return to the details. At a first stage, on 15th January 2026, the Secretary-General issued a circular to contractors requesting information regarding possible non-compliance. The requests were addressed to all contractors and framed in wholly general terms. And just like all other contractors, the applicants responded, providing the requested information and stating that there was no risk of non-compliance. At the second stage, during the first part of the authority's 2026 session, on 6th March 2026, the Commission identified the applicants alone as requiring special attention for possible non-compliance. This measure was adopted without any engagement with the applicants. The applicants still do not know the legal or factual basis for their identification, in particular which specific contractual obligation or obligations it is considered the applicants may be in breach of, and why. During the Council meeting, NORI's sponsoring state, Nauru, and TOML's sponsoring state, Tonga, raised serious concerns that the applicants had been denied due process. But there was no representative of the Commission present, and although Nauru separately wrote to the Commission repeating its concerns, to date, Nauru's questions have gone unanswered. At the third stage, on 16th March 2026, the Commission wrote to the applicants, notifying them of their identification as requiring specific attention to possible non-compliance and requiring the response to 3 questions by 31st May 2026. Once again, these questions were framed in general terms only. The Commission asked whether the applicants had undertaken or planned to undertake activities that may contribute to appropriation of any part of the area or its resources, or that may be inconsistent with the exclusive nature of their contractual rights in the contract area. Of course, the applicants can infer that the underlying concern arises for an application submitted by TMC USA, a separate company within the TMC group, to the US National Oceanic and Atmospheric Administration for an exploration license. But there was not, and there still is not, sufficient clarity to enable the applicants adequately to understand the case against them and to provide a meaningful response. And despite the applicants having repeatedly asked the authority to clarify the factual and legal basis for its questions and to extend the 31st May deadline to allow the applicants to respond after receiving this information, the authority has not provided that clarification and has refused to extend the deadline. Subject only to the Article 90, Paragraph 4 direction of this Chamber, a 4th stage is now imminent. On 19th March 2026, the Council issued a decision stating that it awaits the Commission's report and recommendations on the matter. The effect of the Chamber's direction is only to hold the ring while the Chamber considers the current provisional measures requests. It has no impact on the substance of the requests and the critical need for the respondent not to make decisions on non-compliance without affording due process to the applicants. And as to the basis and need for those requests, the applicants were boxed in by the authority's refusal to assure due process, coupled with its maintenance of the 31st May deadline, and the uncertainty as to what would unfold at the upcoming Commission and Council sessions. In these circumstances, the applicants had no choice but to file the applications and request provisional measures. But even after proceedings were initiated, the applicants have continued to make every effort to find a pragmatic and reasonable solution to this unfortunate unfolding of events. A solution that would ensure, on the one hand, that the applicant's due process rights are protected, and on the other hand, that the authority could receive meaningful and positive substantive responses to the questions that it had raised. If I can ask you to turn to the judge's folder at tab 1, you can see the letter from the applicants to the respondent dated 19th June 2026. Now, the Chamber is, of course, invited to read this letter in full. But if I can invite you to turn now to paragraph 7 on page 2. Here, NORI and TOML confirm their firm commitment to engaging constructively with the authority in good faith. The applicants explain there remains a meaningful opportunity to stabilise the situation and achieve a pragmatic and workable resolution while preserving the integrity of the regulatory framework established under Part 11 of UNCLOS. In this respect, the time, cost and procedural burden associated with the provisional measures hearing may yet be avoided. At paragraph 8, the Chamber will see the 3 limbs to the proposal set out. This reflects the fact that the present request is not about the applicants steadfastly refusing to provide information, but instead about ensuring the due process requirements are in place so that the applicants can understand the respondent's specific concerns and engage in good faith by providing a meaningful response. The first limb of the proposal asks for the provision of further particulars so that NORI and TOML could be placed in a position to understand the case that they are required to meet and to respond meaningfully to the questions posed in the 16th March 2026 letter. The second limb was the extension of the 31st May deadline for the provision of responses so as to ensure that the responses could be provided on an informed basis. By extending the 31st May deadline, the pressure valve would be released and the course could be set for constructive engagement. The third limb of the proposal was the deferral of imminent consideration by the Commission and Council, thereby ensuring that the applicants be afforded a fair and adequate opportunity to respond prior to any further consideration of issues of non-compliance. At paragraph 10, over on page 3 of the letter, the applicants reiterate their respect for the authority and their commitment to engaging in a constructive and cooperative manner to facilitate an efficient, fair and legally coherent resolution of these matters. At tab 2 of your judge's folder, you can see the respondent's response, dated 22nd June 2026. For present purposes, I ask you to turn to the penultimate page of the letter. This is where the authority responded to the applicant's proposed solution. Looking at the first Roman numeral, the authority invited the applicants to a meeting on 29 and 30th of June, but crucially, there was no indication whether and when the further information requested would be provided. Looking at the second Roman numeral, the authority proposed an extension of the deadline to respond to the March questions, but only to July the 5th. Looking at the third Roman numeral, the authority refused to give any commitment of a deferral of consideration by the Commission or the Council. The respondents said it could not do so in advance of the session. But the matter could at least have been slated for consideration at the beginning of the session on 29th June, or indeed at an intersessional meeting. The rules of procedure for both the Commission and the Council allow for the holding of such meetings. But in any event, the pragmatic reality is that there remained and remains the real and imminent risk that the Commission could proceed to consider and make adverse findings or recommendations, and that the Council act on such adverse findings or recommendations without affording a fair and meaningful opportunity to respond. Furthermore, in the following paragraph, the authority required the applicants to withdraw the request for provisional measures. That is to say, it required the applicants to abandon their right to enforceable judicial protection through provisional measures prior to even holding without prejudice consultations. The Chamber will see the applicant's response of 23rd June 2026 at tab 3 of the judge's folder. On page 2, you can see that the applicants agreed to meet on 29th and 30th of June, and I note in passing the absence of any basis for the respondent's assertion in its written statement that the applicants have refused to engage in consultations. The applicants reiterated the importance of being provided with adequate particulars and an assurance that the authority would not take steps, including making findings, statements, or recommendations, pending the applicant's response on a fully informed and procedurally fair basis. The respondent did not send a letter in reply. What the respondent did say in its written statement is that there is nothing to support the applicant's assumption that the Commission will seek to conclude its inquiry process at the upcoming session without ensuring due process, transparency and fairness. But that is a non-answer. It is not a statement that the Commission would not conclude its inquiry, and it tells the applicants nothing about what steps might be taken leading up to an ultimate conclusion. Further, the applicants do not make an assumption, rather they raise legitimate concerns. The supporting basis for those concerns is that due process has not been afforded to date, coupled with the express refusal of the authority to provide an assurance that the Commission will indeed refrain from making a finding or recommendation before ensuring the applicants have been provided with the relevant information and afforded the right to respond meaningfully. In these circumstances, the applicants remain very much exposed to the risk of further steps with respect to the inquiry being made by the Commission and/or the Council prior to this Chamber's final decision in the case, without having been afforded due process. Regrettably, there is now a further issue to introduce. The NORI expiration contract is set to expire on 22nd July 2026. NORI submitted its application for an extension on 19th January 2026 and had expected the matter to be dealt with before now. The Chamber may have seen that in its 29th June letter, and that is at tab 13.4 in your judge's folder, there's probably no need to turn to it right now, the respondent stated that as a result of the direction made under Article 90, paragraph 4, the Commission will not be able to consider NORI's extension application during this session, and as a result, NORI's contract will inevitably expire on 22nd July 2026. As the applicants explained in their letter of 30th June, which is at tab 13.5, that is not correct. In particular, pursuant to paragraph 16 of the Council's decision on procedures and criteria for extension, which is ISBA 21C19, there is a form of temporary automatic extension in that the contract and all rights and obligations under the contract shall be deemed to be extended until such time as the Council is able to meet and approve the report and recommendations issued by the Commission in respect of that contract. Thus, the Chamber's direction under Article 90, paragraph 4, should have no impact at all. And the respondent's position in this respect has come as a matter of genuine surprise and concern. On 1st July, and the relevant letter is at tab 17, NORI sought confirmation from the respondent as to whether its position is indeed that if NORI's extension application is not granted, the respondent will treat NORI's contract as having been expired with effect from 22 July 2026. As NORI explained, if that is the respondent's position, this would constitute an aggravation and extension of the current dispute, and NORI would have no choice but to seek an additional provisional measure ordering the respondent to refrain from taking any position or step which would have the effect of prejudging or determining the legal status of NORI's contract pending a final decision of the Chamber, and to raise this matter before the Chamber in its oral submissions today. The respondent has elected not to respond on the substance, saying late last night that it does not wish to engage in the conduct of litigation by correspondence and will address these matters at the hearing. That is puzzling, and in light of this non-response, NORI will be identifying today why it is entitled to this further measure. Mr. President, members of the Chamber, the structure of the remainder of the applicant's submissions today will be as follows. Ms. Sander will now set out the factual background in more detail, and as ever in a provisional measures hearing, the facts are of key importance. She will be followed by Mr. Ochi, who will address the issue of prima facie jurisdiction, and I will then address the plausible rights at issue in this case and the real and imminent risk of irreparable prejudice. And finally, Mr. Eastwood will make concluding observations. Thank you, Mr. President, members of the Chamber, and may I now ask you, Mr. President, to call Ms. Sander to the podium.
I thank you, Mr. Wordsworth. I now give the floor to Ms. Amy Sander. Madam, you have the floor.
Mr. President, members of the Chamber, it's an honour to appear before you on behalf of the applicants. I will be focusing first on the relevant aspects of the legal framework within which the authority operates, and secondly, considering in further detail the authority's treatment of the applicants. Now, recognising that I will be covering a fair amount of ground, I'll set out now the core takeaways. First, it should be common ground that due process must be adhered to at every stage of the present inquiry into possible non-compliance with contractual obligations. The Council decision of March 2026 expressly states this, and that position is consistent with the recognition of the need for due process when the Commission is considering a risk of non-compliance under its 2024 procedure, a procedure to which the respondent has made express reference in the context of the present inquiry. Second, the questions posed by the Commission to the applicants on 16th March did not make clear the case being put to the applicants and were far from straightforward, which is the respondent's characterisation in its written statement. The applicants did not and still do not understand the authority's position on the scope of the relevant obligations and the factual and evidentiary basis on which the authority considers there to be possible non-compliance. And the respondent's current assertion that the questions posed by the Commission are straightforward sits very uneasily with the respondent's acknowledgement in its 26 May letter that a thorough legal assessment of issues presented in the applicant's request for further information and clarification was required and before meaningful and constructive engagement could occur. Third, without providing the information and clarification requested, the respondent repeatedly insisted that the applicants must respond by 31st May. Furthermore, it didn't provide any assurance that the Commission would not proceed to make some finding, recommendation, or statement concerning the applicant's compliance at the Commission session scheduled to commence on 29 June. And this stance was taken in circumstances where the Council has expressly stated that it awaits the Commission's recommendation. Fourth, the respondent has thus regrettably failed and continues to fail to ensure due process with respect to the inquiry, and has given strong indications that further steps will be taken before the applicants are afforded the opportunity to understand the case against them and meaningfully respond. I turn then to the first part of my submission, the legal framework relevant to the authority's engagement with and treatment of contractors regarding risk of non-compliance with their contractual obligations. And I draw out two overarching points. First, both the Council and Commission clearly have a central and important role in this respect. The applicants do not dispute that, and indeed have repeatedly affirmed and demonstrated that they're committed to constructive and good faith engagement with an inquiry concerning compliance with their contractual obligations. Second, and equally clearly, there are certain due process requirements that must be adhered to in the discharge of this role, as expressly recognised in the authority's own documents. So, turning to the role of the Commission and Council, this is broadly common ground, but it is useful to recognise that there are different players involved, each with its own perspective. First, the contractor. And from its perspective, there are a number of important obligations. And here it's instructive to look at the three standard contractual clauses highlighted by the respondent, a copy of which are in the Judges folder at tab 4. Section 10.1 provides that the contractor shall submit annual reports to the Secretary-General. And moving down to 10.3, those reports shall be supplemented by such additional information as reasonably required by the Secretary-General. If the Chamber turns over leaf to look at section 27, this is entitled applicable law. 27.1 affirms that the contract shall be governed by the terms of this contract, the rules, regulations, and procedures of the authority, Part 11 of the Convention, the agreement, and other rules of international law not incompatible with the Convention. At 27.2, it provides that the contractor, its employees, subcontractors, agents, and all persons engaged in working or acting for them in the conduct of its operations under this contract shall observe the applicable law and shall not engage in any transaction directly or indirectly prohibited by it. If we turn back to section 13, entitled Undertakings, 13.1 provides that the contractor is obliged to carry out exploration in accordance with the applicable law. 13.2 sets out various undertakings, including at subparagraph B, to comply with the cited applicable obligations. 13.2d and 13.4 provides that, to summarise, both the applicants and the authority shall act in good faith. And it's very important indeed to the applicants that they comply and be in a position to comply with all their obligations. The second of the four perspectives is that of the Council. As the executive organ of the authority, pursuant to Articles 1622A and 1622L of UNCLOS, it has the power to monitor, evaluate compliance of the contractor with its obligations, call for further information, and ultimately take enforcement action against the contractor if necessary. The Council's rules of procedure provide that the Council can decide the frequency of its regular sessions and can convene special sessions. The third perspective is of the Commission. As a subsidiary organ of the Council, the Commission assists the Council by providing information relevant to the Council's evaluation of compliance. Thus, pursuant to the Commission's powers as set out in UNCLOS Articles 1652A and 1652C, the Commission reviews the contractor's annual reports, identifies any concerns in relation to the compliance of the contractor's contractual obligations, and liaises with the contractor in regard to those concerns. The Commission's rules of procedure provide that the Commission shall meet as often as required, including in emergency sessions. The chair of the Commission or a member of the Commission may attend when the Commission's report, including any recommendations, is then considered by the Council. Fourth, the Secretariat's perspective. As described by the respondent, the Secretariat is responsible for administration and is led by the Authority Secretary-General. So against that backdrop, I now turn to address the respondent's 2024 procedure on inadequate performance and its 2025, and I quote here, possible non-compliance process. And I'm going to address this in a little detail, and the reason for this is twofold. First, to take you to the documents where the right to due process is affirmed, and as already explained, the crux of the applicant's request for provisional measures concerns their right to due process. Second, to explain that both the 2024 procedure and the 2025 process are concerned with risk of non-compliance. And, unsurprisingly, both were expressly referred to by the respondent when transmitting the 16 March questions to the applicants. And it's perplexing that the respondent now seeks in its written statement to dismiss the relevance of the 2024 procedure to its current inquiry. If I can ask the Chamber to turn to tab 5 of the folder, the document labelled ISBA 29 LTC 5, this is the 2024 document that the respondent has labelled in its written statement the inadequate performance procedure, and which I will call the 2024 procedure. So at this time, the authority is considering how to go about identifying and then publicly naming contractors that responded inadequately or failed to respond to issues of concern raised by the Commission in relation to their contractual obligations. And one sees that from the document title and the first two paragraphs. Turning to page 2, the last sentence of paragraph 8, the Commission explains that concerns identified by the Commission in the review of annual reports do not necessarily imply a contractor's non-compliance with its contractual obligations. So the focus is on identifying possible non-compliance. If you can now please turn to page 3 of this same document, at paragraph 9, the first sentence, the Commission elaborates that the process identifies contractors on the basis of their failure to respond to calls from the Council or their inadequate or incomplete responses to the Commission, short of non-compliance with contractual obligations. Elsewhere, the document expressly refers to the contractor as being identified as at, and I quote, risk of non-compliance. Appendix 2, this is for your reference at page 7 of the document, lists a number of obligations and explains at the top of page 7 that the issues raised by the Commission may vary widely in severity and scale, but do not necessarily imply a contractor's non-compliance with the obligation. So again, the focus is on risk of non-compliance, that is to say, possible non-compliance. Turning back to paragraph 9 on page 3 of this document, we see that in this context, it was expressly recognized by the Commission that, and I'm reading from the slide here, a key concern relates to the issue of due process. It is an elementary due process requirement, as well as a requirement of legal certainty, that contractors are aware of the potential measures and penalties to which they may be subject, depending on their contractual performance in advance. In the following paragraph, the Commission then elaborated on what due process requires, stating that in that context, the process for identifying contractors that may not have responded or may have responded inadequately shall be A, neutral and objective, B, transparent, giving due regard to confidentiality obligations, C, timely and efficient, bearing in mind the workload of the Commission and the timing of reviews of annual reports, and D, one that elicits positive responses and encourages contractors generally to carry out their plans of works effectively. So the Commission here recognises as facets of due process the importance of, notably, transparency and eliciting positive responses. So taking all this together, first, the 2024 procedure clearly applies where there is a risk of non-compliance. Second, the Commission has recognised that due process requires that the contractor understands the case against them and is afforded an opportunity to respond meaningfully, reflecting those central tenets of transparency and eliciting positive responses. Third, those due process requirements apply regardless of the particular obligation under consideration and the severity and scale of the concern. Fourth, the 2024 procedure therefore reflects a broad recognition of the importance of due process requirements when engaging with contractors with regard to a risk of non-compliance. Fifth, as to why due process is so significant in this context, the 2024 procedure recognises that a risk of non-compliance may have important consequences. In instances of non-compliance, the Council has the power to issue punitive measures. In principle, the authority might seek to rely on a finding of non-compliance when invoking termination provisions under the contract or refusing to extend an existing contract. In addition, the 2024 procedure implicitly recognises that both the identification of the contract as at risk of non-compliance and the public naming of a contractor in relation to possible non-compliance has potentially significant consequences. I ask the Chamber now to turn to the Council decision of July 2025 in your folder at tab 6 and headed ISBA 30C19. Turning to paragraph 4, the Council welcomes the Commission's process of identifying and naming contractors requiring further attention in accordance with the 2024 procedure. The procedure that we've just seen expressly recognises the importance of due process. If one turns to paragraph 6, here the Council requests the Secretary-General to continue the practice of communicating issues identified by the Commission to the relevant contractors, to follow up in writing with those contractors, and to request meetings with them. So again, we see an emphasis on a transparent process that elicits positive responses. And the reference to meetings is a significant one. Where contractors are identified as requiring specific attention, contractors have been invited to a virtual exchange of views with the Commission to facilitate detailed exchange of views on ongoing concerns and enhance mutual understanding and expectations. And such meetings have been held with contractors intersessionally, that is to say, outside of the Commission's formal sessions. I now move to what the respondent has framed as a distinct possible non-compliance process. We're still looking here at the July 2025 Council decision at tab 6, but if I can ask the Chamber to turn to paragraph 9. And here the Council also requests the Secretary-General to require, in accordance with section 10 of the standard clauses, which we looked at earlier, additional information from contractors at risk of non-compliance with their contractual obligations, citing sections 13 and 27 of the standard clauses, which, as I noted earlier, set out relevant obligations. And paragraph 9 provides that it is the Commission that considers the additional information and is then to report and make appropriate recommendations to the Council. Moving to paragraph 10 in this document, this paragraph is inextricably connected with paragraph 9. It's set out, and I quote, with reference to paragraph 9. The Commission is urged to pay specific attention to contractors' possible non-compliance with their obligation under section 27 to observe the applicable law. And paragraph 10 refers in particular to where such non-compliance may arise out of direct or indirect actions related to activities in the area, including contractual obligations to act in accordance with the multilateral legal framework established by ITLOS. If the Chamber can now turn to the third document, the Council decision of 19 March 2026 at your folder at tab 7, and one can see from the title of this decision that it relates to a request of additional information from contractors at risk of non-compliance with their contractual obligations. So looking at the preamble, at the second preambular paragraph, it refers to the July 2025 Council decision we've just looked at. Moving to the fourth preambular paragraph, it refers to the Commission inquiry conducted pursuant to that decision. And the sixth preambular paragraph is referring to steps taken as part of that inquiry. The final preambular paragraph explains that identification for specific attention to possible non-compliance under paragraph 10 of the July 2025 decision is a preliminary step and does not constitute a finding of non-compliance. And that's a point that the respondent emphasises in its statement. The identification is for possible, that is to say, risk of non-compliance. So pausing there, at the point at which the Commission is posing questions to contractors pursuant to paragraphs 9 and 10 of the July 2025 Council decision, the Commission has already considered whether there exists a risk of non-compliance or possible non-compliance, and it's already answered that question in the affirmative. So in substance, this is no different to the identification of the existence of a risk of non-compliance, possible non-compliance, under the 2024 procedure. And as we've seen, the respondent has recognised that due process requirements apply before and following making such a determination. It follows that the same due process requirements are equally applicable. So looking again at this 2026 March decision, we're still at tab 7, at paragraph 4, the Council supports the Commission's continuation of the inquiry, stating that it awaits the Commission report and recommendations. Now, importantly, and consistent in particular with the 2024 procedure, at paragraph 4b, the Council requests that the Commission, in taking the matter forward, continue to ensure due process, transparency and fairness at every stage in the conduct of this inquiry, including by providing contractors and sponsoring states with the right to respond. So consistent with the previous two documents of 2024 and 2025, which I took you to, we see here in March 2026 an express affirmation of adherence to due process, including transparency and a right to respond. And moreover, this instruction to continue to ensure due process at every stage is a recognition that due process requirements apply at every stage of the present inquiry. That includes the initial identification of the applicants as requiring specific attention, as well as the subsequent consideration of possible non-compliance and, of course, any later recommendation addressing non-compliance. Now, the respondent argues for a strict distinction between the 2024 procedure and the processes under paragraphs 9 and 10 of the 2025 Council decision, and they say this is crucial for the present case. But the distinction is artificial, and the authority itself has recognised expressly that the 2024 procedure does remain relevant. So while the respondent asserts in its statement that it was expressly stated on the face of the requests of 16 March 2026 that they were made pursuant to the 2025 decision and not pursuant to what it frames as the distinct 2024 procedure, you can see the contrary from the cover letter from the Secretary-General transmitting the 16 March request to the applicants. If we take the cover letter addressed to NORI at tab 8 of the Judges folder, the Secretary-General states the questions are advanced in the context of its ongoing assessment of the performance of contractors as stipulated in ISBA 29 LTC 5. That's the documentary reference for the 2024 procedure, and in line with the 2025 decision. The Chamber will see the letter addressed to TOML similarly refers to the questions being advanced in the context of the ongoing assessment as stipulated under the 2024 procedure. I turn now to the second part of my submissions, where I will address in further detail the authority's treatment of the applicants. First, I will address the initial identification of the applicants as requiring specific attention for possible non-compliance in the Commission report of 6 March 2026, highlighting the lack of prior notification and engagement with the applicants. Second, I will address the Commission's questions of 16 March, drawing out the point that the respondent did not make clear the case of possible non-compliance being put to the applicants. Third, I will address the respondent's response to the applicant's request for further information, for clarification, drawing out how this response was inconsistent with fundamental requirements of due process. So turning then to the applicant's initial identification in the 6th of March Commission report, and I'll make 4 points. First, the respondent says that the initial identification of the applicants as requiring specific attention as to possible non-compliance is a preliminary step, which does not constitute a finding of non-compliance. But due process requirements still apply at that earlier stage of the inquiry, as reflected by the Council's position that the Commission should continue to ensure due process at every stage, which of course is consistent with the Commission's recognition of the need for due process when identifying contractors under the 2024 procedure. Second, prior to the Commission's report of 6 March, the applicant's only relevant engagement with the respondent was with the Secretary-General, who in a circular of 15 January 2026 requested information from all 21 contractors. So whilst the Secretary-General referred to paragraphs 9 and 10 of the July 2025 Council decision, pursuant to which you'll recall the Secretary-General is tasked with requiring information from contractors who are at risk of non-compliance, there was correctly no suggestion that the applicants had been so identified. Third, like all the other contractors, the applicants responded to the Secretary-General providing the information requested. It did so in good faith and notwithstanding concerns as to the legal basis. Fourth, and a key point, is that when on 6 March 2026 the Commission proceeded to identify the applicants alone as requiring specific attention for possible non-compliance, the applicants received no prior notification, consultation, or information as to the reasons for this designation, beyond the Commission's reference to unilateral regimes and to possible non-compliance with obligations to act in accordance with the multilateral legal framework established by the Convention and Agreement. So the respondent now contends this didn't amount to naming the applicants, drawing attention to the fact that the Commission referred to one already identified contractor requiring specific attention and one other contractor. But the respondent's position is unpersuasive. Which other 2 contractors could the Commission have been referring to as being identified for specific attention on the basis of possible non-compliance with obligations to act in accordance with multilateral framework and in the context of a concern regarding unilateral regimes? Noting that identification follows an express reference made just 2 paragraphs earlier to the TMC US NOAA application. But at the same time, however, and contrary to the respondent's assertion in its statement, the applicant's core concern is not naming as such, but identification as to possible non-compliance without being afforded due process, including the opportunity to know the case against them and to respond meaningfully. That is a requirement that, as I have explained, the Council has recognised applies at every stage of the inquiry. I turn now to the 16 March 2026, when the Commission wrote to the applicants, notifying them of their identification as requiring specific attention as to possible non-compliance, and requiring the applicants' response to 3 questions by 31st May 2026. 3 preliminary points before I turn to the Commission's 3 questions. First, it's helpful to look at an example from the Commission concerning possible non-compliance, which the applicants accept is sufficiently clear to be understood and responded to meaningfully. If I could ask you the Chamber to turn to the Commission's letter to TOML of 16 March in tab 9 of the Judges folder. Annex 1 to this letter sets out the Commission's question under the 2024 procedure, which you now see on the screen. Here, the Commission identifies a specific concern relating to a specific activity and asks specific questions. The Commission acknowledged the contractor is planning a joint offshore cruise with IOM in the second half of 2026 to the TOML contract area to conduct environmental baseline research. The Commission requests the contractor to provide an update on the scheduling of this joint cruise, specify the scope and objectives, as well as clarify how much of the sampling will be carried out in the TOML area. TOML responded promptly and fully by the deadline of 31st May 2026. I should note that TOML's response is not on the case file, but it's referred to in Annex 8 of the respondent's statement and is, of course, in the respondent's possession. Second preliminary point. Through the Secretary-General's circular of 15th January 2026, the respondent had already requested any information related to the contractor or other relevant third parties where possible non-compliance may arise out of direct or indirect activities in the area, including contractual obligations to act in accordance with the multilateral legal framework established by the Convention and the Agreement. In its report of 6 March 2026, the Commission recognised that the applicants had provided the information requested and that the applicants had confirmed there were no incidents, accidents or events that might place them at risk of non-compliance with their contractual obligations. The Commission evidently disagrees and considers that such a risk does exist in connection with TMC USA's application to the US authorities. And it's incumbent on the respondent to engage meaningfully with the applicants by identifying the legal and factual basis for its concerns. That is why it disagrees with the applicants. And if the applicants are kept in the dark in that respect, yet required to respond, there's every chance that the Commission will consider that the applicants' responses do not address its unarticulated specific concerns. And in turn, there's a real risk that the Commission might conclude that the applicants have failed or even refused to engage meaningfully, with the ensuing risk as to how that informs any recommendations the Commission might make. Is therefore critical to the applicants to ensure that they understand the Commission's specific concerns and are able to engage with those concerns meaningfully and in good faith. Third preliminary observation. It is important to note that the Commission itself has recognised that these questions of conduct outside the multilateral legal framework as established by the Convention give rise to what it has described as unprecedented legal questions, including specifically in relation to contractors. And the Secretary-General has even proposed a possible request for an advisory opinion from this chamber on certain of those unprecedented questions as they pertain to members of the authority. So turning now to the Commission's 3 questions in its letter of 16 March 2026, which are at issue in this case. The questions are at tab 8 of the judge's folder, and I will take them in turn. Question 1, which the chamber will see on the screen, states, has NORI or TOML directly or indirectly undertaken or plans to undertake any activity which may contribute to the appropriation of any part of the area or its resources outside the multilateral framework of UNCLOS? Now, the applicants entirely accept there are certain inferences one can draw from the general framing of the question. First, there's an apparent concern that the applicants may have undertaken or plan to undertake an activity or activities which may contribute to appropriation of part of the area or its resources outside the multilateral framework of UNCLOS. Second, based on the reference to appropriation of part of the area or its resources, the Commission appears to be focused on Article 137 of UNCLOS on the legal status of the area and its resources. Third, one can also infer that the concern arises from the application of TMC USA to the US National Oceanic and Atmospheric Administration, NOAA, for an exploration license. But that is not sufficient clarity to enable the applicants adequately to understand the Commission's concern, i.e. the case against NORI and TOML, which they must answer, and to provide a meaningful response. Far from expressing a specific concern, it was reasonable for the applicants to consider that question 1 indicates a series of unarticulated assumptions or positions and glosses over various legal and factual issues. I'll give 4 examples of the uncertainties and confusions the applicants were left with and which reasonably called for clarification. First, even if it is inferred that this refers generally to the license application of TMC USA, where are the details as to the specific activity that the Commission is referring to? The only guidance in this respect is the phrase inter alia sharing data or other information in question 3, to which we'll turn. But what data is the Commission concerned about? And noting the inter alia, in addition to data sharing, what other activities are the Commission asking about? Second, what does the Commission mean when it asks about a contractor indirectly undertaking an activity? Is the Commission suggesting that the conduct of a separate juridical person that's related to a contractor in the sense that it forms part of the same overall group of companies somehow automatically amounts to indirect conduct of the contractor? And that question arises because, as the respondent itself has emphasised, TMC USA is not legally recognised as a contractor by the ISA. And plainly that's correct. The 2 applicants and TMC USA are 3 separate companies within the TMC group. Neither applicant is a parent company or a subsidiary of TMC USA. And there are no common directors as between either applicant and TMC USA. Or perhaps the Commission is suggesting that the applicants themselves have taken some positive action, which amounts to indirectly undertaking the relevant unspecified activity concerning the Commission. Some specifics are needed. Third, what does the Commission mean when it asks whether the applicants may contribute to appropriation? Perhaps, consistent with the unspoken view as to the meaning of indirectly, is the Commission thinking that through the corporate structure of TMC, the applicants might be contributing to appropriation by TMC USA or the USA? Is it being suggested that as a matter of interpretation of Article 13C, the applicants are under a positive duty not to recognise any rights conferred on TMC USA by the US authorities? If so, the applicants are entitled to know that that's the case that they must answer. Fourth, relatedly, it's also not clear whether the Commission is concerned with the risk of contributing to appropriation by TMC USA or the USA. If the former, does the Commission consider that Article 1371 also binds juridical entities which have not concluded a contract with the ISA, with the authority? Or if the latter, then this raises the important question of the Commission's position on the nature and scope of the obligations under Article 137 of the Convention. Now, the applicants, of course, accept that the questions set out in 16 March 2026 are to be read in the context of the standard clauses of the contract. But what specific obligations or aspects thereof does the Commission consider that the applicants have possibly breached? And that's a question of the greatest importance to the applicants. The respondent may contend that question 4 must be read together with section 27.2 of the standard clauses. The Secretary-General didn't refer to section 27.2 in her letters to the applicants of 16 March. However, the respondent has consistently referred to this provision in the context of the present inquiry. But in any event, reading section 27.2 raises more questions. As I took you to, section 27.2 requires that the contractor, its employers, subcontractors, agents, and all persons engaged in working or acting for them in the conduct of its operations under the contract shall observe the applicable law referred to in section 27.1. So is the reference to the employees, subcontractors, agents, or other persons working for or acting for the applicants in the conduct of their operations under the contracts? And if so, to which of these do the Commission's concerns relate? And what is it that those relevant third parties are alleged to have done in the conduct of their operations under the ISA contracts that gives rise to the Commission's position on possible non-compliance? The respondent has also specifically invoked the applicant's, has previously specifically invoked the applicant's obligations under section 13.2 of the standard clauses to act in good faith and to accept its control over activities in the area. Neither of these provisions were referred to in the 16 March 2026 questions, and the respondent has provided no explanation as to why it considers there may be a risk of non-compliance with either obligation. Although it's not set out in the questions and it's unclear, the Commission may be suggesting that TMC USA's application to the US authorities amounts to the applicant somehow participating in the UNCLOS scheme in bad faith. And if so, the applicants are entitled to know the case against them, including the facts and evidence which the Commission considers might substantiate such a serious allegation. But pausing here, I recall that the purpose of setting out all these uncertainties and queries arising from the questions posed to the applicants on 16th March is not because of any expectation or challenge for the respondents' lawyers to attempt to reply now with neat answers wrapped up in a bow. The point is that these are all entirely reasonable queries for the applicants to have, and ones that could have readily been addressed as part of a constructive and transparent process, ensuring the applicants adequately understood the case it was meeting and could meaningfully engage prior to the respondent's deadline. To the extent the respondent's position is that there are neat answers, and that would be surprising given the respondent's own recognition that unprecedented issues arise in this context, that simply makes it all the more perplexing as to why the respondent could not have engaged with the applicants back in April, or, on the respondent's position that this was not feasible, extended the 31st of May deadline to allow time to do so once the Commission's official session resumed. I turn now to the second question, question 2 of 16 March 2026, which is on your screen and reads, has NORI TOML undertaken or plans to undertake any activity in any manner whatsoever contrary to or inconsistent with its exclusive rights in the area of its exploration contract? So as with question 1, the applicants accept that there are some inferences that could be drawn, but these are limited. The respondent has a concern about activity which may be contrary to or inconsistent with the applicant's exclusive rights in the contract area. This appears to be a reference to Article 3(4)(c) of Annex 3 to the Convention, which provides that a contract shall confer on the operator the exclusive right to explore for resources in the area covered by the plan of work. But what specific obligation does the Commission think that the applicants may have breached? 3 additional confusions and uncertainties. First, again, there's no indication of what activities, other than data sharing, the Commission is concerned by. Second, there's also no explanation of why the Commission considers that TMC USA's application, which isn't referred to but which the applicants presume is what this is all about, may be inconsistent with the exclusive nature of the applicant's contractual rights. And this needs to be unpacked so that the concern can be understood. What does the Commission think the exclusive nature of the applicant's right implies, including as a matter of interpretation of Article 3(4)(c)? Third, in relation to whom does the Commission consider that the applicants may be acting inconsistently with their exclusive rights? Is it TMC USA, perhaps the USA, perhaps both? So turning to question 3, and as I've already noted, the Commission asks about data sharing specifically. Question 3 is on the screen and reads, in light of the 2 previous questions, can NORI TOML specify whether such activities may have included or will include inter alia, sharing data or other information appertaining to its exploration work pursuant to its contract with the authority to any entity or person outside the framework of such contract? So whilst question 3 at least allows for a focus on a particular type of activity, clarification is still required to allow the applicants to understand the Commission's concerns and meaningfully respond. First, what is the Commission's position on the permissibility of the applicant sharing data or information? Should question 3 be read as implying A, that all data or alternatively certain data can never be shared outside the contractual framework, B, that sharing is allowed only where the respondent is given its permission, and or C, that the respondent owns all or certain data? Second, what specific obligations does the Commission think may have been breached? And relatedly, what does the Commission consider to be the source under the applicable law of any restriction on sharing data? Third, what does the Commission consider to be the scope of any such restriction? Should question 3 be read as implying A, that all data, or alternatively certain data, can never be shared outside the contractual framework? B, that sharing is allowed only where the respondent is given its permission, and or C, that the respondent owns all or certain data? And how does any such claimed restriction sit alongside the rights of the contractor with respect to that data, including under Regulation 36 of the Exploration Regulations? I turn finally to the respondent's response to the application's request for further information and clarification with respect to the 3 questions. The respondent asserts that the 3 questions are, and I quote, unambiguous and straightforward, including because its concerns about unilateral activities in the area outside the multilateral framework of the area are concerns which are widely publicised. But as indicated earlier, this assertion of straightforwardness is belied by 3 points. First, if the respondent's concerns had been clearly identified, there should have been no difficulty in providing the clarifications requested by the applicants. Second, in fact, the respondent's responses to the applicant's requests for further information and clarification is consistent with the applicant's positions that the questions were not straightforward. Taking the response of 13 May, the Commission Chair stated that it was not procedurally appropriate or feasible for the Commission to address the applicant's concerns prior to the session commencing on 29 June. Well, we know the Commission has held detailed exchanges during the intersessional period, and the respondent says, well, these are not comparable, I quote, to the type and extent of intersessional work which would be required to address the applicant's various requests and queries. So this sits awkwardly with the respondent's current stance that the position is straightforward. Turning to the further response of 26 May, as I indicated earlier, here the respondent acknowledged that a thorough legal assessment of issues presented in the applicant's request for further information and clarification was required before meaningful and constructive engagement could occur. Third, and as I've just illustrated, it was entirely reasonable and understandable for the applicants to consider that the Commission's case against them could take several forms depending on the nature and extent of the specific concerns, the respondent's position on various legal issues and the factual basis for those concerns. And it's a fundamental principle of due process that the person facing an inquiry is entitled to know the case against them. That is the case which they're required to answer. Yet, critically, not only did the respondent not provide the further information and clarification sought, it insisted on a deadline of 31st May 2026 for the applicant's responses. Why? Why not release that pressure valve to allow time for the respondent to first ensure the applicants fully understood the case they'd met, and thus elicit a positive response and allow for meaningful and constructive engagement? Furthermore, with the upcoming Commission meeting scheduled to commence on 29 June, the applicants were and remain faced with the real risk of further steps being taken by the authority, notwithstanding the applicant's inability to adequately understand and respond meaningfully to the respondents' questions. 2 points on this. First, Having already found that there's a risk of non-compliance requiring special attention, in principle, the Commission's next step could be a finding relating to possible non-compliance by the Commission, or even a recommendation in this regard. Indeed, the Chamber will recall that the 2025 Council decision expressly provides for the Commission to make appropriate recommendations, which the Council would then consider. The Commission had stated in its 6 March report that it will report to the Council on this issue during the second part of its 31st session, and the Council expressly stated in its March 2026 decision that it awaits the Commission's report and recommendations with respect to this inquiry. My second point, the applicants simply do not know what the Commission or Council will do because they've not been told how the process should unfold. Here's what the applicants do know. They know the respondent now wishes to portray the applicants as having steadfastly refused to provide any substantive response and having, I'm quoting, refused to collaborate with the inquiry. The applicants know that the respondent refused to provide any assurance that the Commission will not make a recommendation relating to possible non-compliance or otherwise progress the inquiry. That was clear from the recent correspondence that Mr. Wordsworth took you to. The applicants know that the Commission has its Part 2 session 29 June to 10 July and that the Council meets 24th of July. And it also knows that there's a possibility of a third part to the session being held, and that in any event, the Commission may meet as required, including by way of emergency session. The applicants know that the Council's indicative programme of forthcoming work for the current Part 2 session expressly provides that on 20 July, the Secretary-General will report on the implementation of the decision of the Council in 2025 relating to the reports of the Commission, i.e. the Commission's report addressing the applicant's compliance, a report which the programme indicates will be provided to the Council by 14 July. The respondent's statement asserted that there's nothing to support an assumption that the Commission will seek to conclude its inquiry process without ensuring due process. But assuming the conclusion referred to here is the Commission's recommendation addressing the applicant's possible non-compliance, this is all notably elliptical. Nothing is promised. There's no explanation as to how the Commission would or even could, consistent with that programme of work, accord due process to the applicants, including because the respondents would first need to provide the required information and clarifications, and then afford the applicants an opportunity to consider and respond. On receipt of the respondent's letter dated 29 June, the applicants learned a little more, namely that the Commission did indeed intend to consider the issues raised by the applicants in their claims, and an inference from the terms of this letter is that the Commission intended to issue a recommendation in relation to the applicants. The letter indicates that the Commission planned to consider matters of procedure, transparency and fairness raised by the applicants. However, it didn't indicate whether or how the applicant's specific due process concerns were to be addressed, including whether, and if so, how and when, as the necessary first step, the required information and clarifications would be provided. Although the respondent now says that the consequence of the Rule 94 direction is that the Commission cannot now consider any of the issues relating to the applicant's due process concerns, nor issue a recommendation in the current session. That does not impact on the current need for a provisional measures order. And of course, as to future meetings of the Commission, the applicants don't know what may unfold. As I noted, there remains the strong possibility of a third part to the session being held, and in any event, the Commission may meet as required, including by way of an emergency session. Mr. President, members of the Chamber, it is in this factual context, with the applicants left to infer and then formulate itself the specific case against them, and not even knowing when and what further steps the respondent may take, that the applicant's request for provisional measures is sought from this Chamber. I thank you for your attention. Mr. Oki will next address you on the issue of prima facie jurisdiction, and we are in the Chamber's hands as to whether now is a convenient time to take the break.
Thank you, Ms. Sander. I think it would be appropriate for the Chamber to withdraw for a break of exactly 15 minutes. Thank you.
All right, veuillez vous lever. All rise. Veuillez vous lever.
Please be seated. I would like to continue with the hearing. I invite Mr. Sean Ori to make his statement. Sir, you have the floor.
Mr. President, members of the Chamber, it is an honour to appear before you on behalf of the applicants in these proceedings. I will address prima facie jurisdiction. As stated in Article 90, paragraph 1 of UNCLOS, the Chamber may only prescribe provisional measures if it considers that prima facie it has jurisdiction under Part 11, Section 5 of UNCLOS with respect to the dispute. As is well established in the jurisprudence of the Tribunal, the standard does not require that the Chamber finally satisfy itself that it has jurisdiction. Rather, the Chamber need only be satisfied that the provisions invoked by the applicant appear prima facie to afford a basis on which jurisdiction might be founded. The applicant's position is that the Chamber clearly has jurisdiction over the present dispute under Article 187, paragraph C of UNCLOS. The respondent, however, contests prima facie jurisdiction on three bases. The respondent contends, first, that the requirements of Article 187, paragraph C are not met. Second, that the limitation on jurisdiction in Article 189 of UNCLOS is engaged. And third, that the applicant's claims are premature, asserting that no dispute has crystallised. My submissions will address three topics. First, I will explain that the dispute had crystallised when the applicants instituted these proceedings. Second, I will set out why there is no doubt that the requirements of Article 187, paragraph C are met on at least a prima facie basis. Third, I will demonstrate that the dispute does not fall within the limitation on jurisdiction in Article 189. I turn to my first topic. As I have noted, the respondent contends that no dispute has crystallised. This is incorrect. A dispute has crystallised between the parties, and had already crystallised before the applicants transmitted their applications to this chamber, instituting these proceedings on the 30th of May 2026. As you've heard this morning, the crux of this dispute between the parties concerns the applicable requirements of due process and whether the authority has complied with those requirements. As to the law, as the Chamber will know, there are two key principles. First, the dispute between the parties must have existed at the time of the filing of the applications. Second, as the Special Chamber recalled in Mauritius, Maldives, a dispute is a disagreement on a point of law or fact, a conflict of legal views or of interests. What must be shown is that the claim of one party is positively opposed by the other. This is the case where it is demonstrated on the basis of the evidence that the respondent was aware, or could not have been unaware, that its views were positively opposed by the applicant. Applying this test to the facts of the present case, there is no doubt that a dispute had crystallised at the date of filing the applications. It suffices to recall 5 exchanges between the parties, all in 2026. Most of these have already been addressed earlier this morning. First, on the 16th of March, the applicants were informed that the Commission had identified them as requiring specific attention to possible non-compliance, and that they were to transmit their responses to 3 questions by no later than the 31st of May. Second, on the 21st and 22nd of April, respectively, the applicants wrote to the Chair of the Commission. The letters can be found at tab 11 of the Judges folder. If I can ask the Chamber to turn to paragraph 3 in tab 10. Here, the applicant's position is set out squarely and in identical terms in both letters. They asked for confirmation of the procedure that the Commission intends to follow, and further clarification and particulars in respect of the questions raised and their legal bases, so that NORI may provide a complete and informed substantive response. In the next paragraph, the applicants recalled that, as expressly recognised in an earlier Council decision in July 2025, the Commission is to conduct its assessment with due process, transparency and fairness at every stage of the inquiry. And at paragraph 2022, mindful of the fast approaching 31st of May deadline for their responses, the applicants requested a response by the 8th of May, noting that if no response is received from the Commission, NORI, TOML, will consider that the requests set out in this letter are denied. No response was received by the 8th of May. Third, on the 13th of May, the Commission Chair responded to the applicants, stating that she was declining to express any position on the matters raised, pending the Commission's consideration during the current ongoing session. Despite this, the Chair stated the deadline of 31st of May remains in full effect. Fourth, on the 18th of May, the applicants wrote to the Respondent Secretary General. This letter is in the Judges folder at tab 11. At paragraph 1, the applicant stated, and this is on the screen, that they were providing formal notice that a dispute has arisen between NORI, TOML, and the authority within the meaning of Part 11, Section 5 of ITLOS, including Article 187, Paragraph C, subparagraphs 1 and 2. At paragraph 12, the applicants detailed the nature of the dispute between the parties. They stated, and this is also on the screen, nature of the dispute. The dispute concerns, inter alia, the identification of NORI for specific attention without disclosure of evidence, criteria, or methodology, the failure to afford NORI and its sponsoring state basic procedural safeguards prior to and following the determination of NORI for specific attention, including the failure to comply with the Council's binding decision, ISBA 31C18, requiring due process, transparency and fairness at every stage, and providing contractors and sponsoring states a right to be heard and address any allegations raised concerning their conduct. C, the authority's failure to respond to NORI's letter of 21st of April 2026, requesting further particulars, disclosure of the legal bases relied upon, and confirmation of applicable procedural safeguards. D, the continuation of the inquiry in circumstances that deprive NORI of a meaningful opportunity to understand and respond to the case it is said to meet. And E, the interpretation and application of the exploration contract between NORI, TOML, and the authority. The applicants also requested consultations as a matter of urgency by the 29th of May. Turning now to the fifth exchange between the parties, on the 26th of May, the Secretary-General wrote to the applicant. There are 3 points. First, like the chair of the Commission, the Secretary-General also declined to engage substantively with the applicant's due process concerns and requests. Second, the Secretary-General also failed to engage at all with the applicant's statement that a dispute within the meaning of Article 187, paragraph C, had arisen between the parties. The respondent did not deny the existence of a dispute. Rather, the Secretary-General simply stated that the notice of dispute had been forwarded to the Commission, which was evaluating how the applicant's concerns and requests may be accommodated. Third, the Secretary-General also stated that consultations in relation to the notice of dispute should be initiated, quote, at an appropriate time after a thorough legal assessment of the issues by the respondent. But there was no withdrawal of or extension to the 31st May deadline for the applicant's responses to the questions of 16th of March. The Secretary-General was silent on this critical matter. Faced with that imminent deadline and the Council's clear indication in advance of the current now ongoing session that the Commission's report and recommendations are awaited, there was clearly a disagreement, including concerning the requirements of due process, and the applicants were left with no alternative but to commence these proceedings. From that brief recap of the exchanges between the parties, it is clear that a dispute had arisen between the parties by the 18th of May, or at the latest by the 26th of May. The dispute included disagreement over what due process requires and whether the authority was complying with those requirements at every stage of the inquiry. Plainly, the authority disagreed that the applicants had the due process rights they asserted, in particular a right to the information and clarifications they requested before the applicants were required to provide their written responses, and/or the authority refused to comply with those due process requirements. The respondent raises 3 counterpoints, none of which undermine the fact that a dispute had crystallized. First, the respondent says that there has been no finding of non-compliance by the applicants. That is correct. The identification of the applicants as requiring specific attention as to potential non-compliance is not a finding of actual non-compliance. The respondent is now considering the next steps, and it has refused to provide any assurances as to whether a finding, statement, or recommendation of actual non-compliance might be made during the current ongoing session before the applicants are afforded the necessary clarifications and an opportunity to respond meaningfully. The dispute, contrary to the respondent's assertion, the preliminary nature of its identification of the applicants is irrelevant, The dispute between the parties is not as to whether the applicants are in breach or even potential breach of their exploration contracts. The dispute concerns a critical antecedent issue, namely what requirements of due process are applicable to the authority's inquiry, including the steps taken so far, and have those requirements been complied with. The respondent's second point is an assertion that no dispute has crystallised because the Council has instructed the Commission to ensure due process at every stage, and an emphasis that the Commission is committed to discharging its responsibilities in accordance with its mandate and procedures. The applicants, of course, agree that the Commission is required to accord due process at every stage, as you've heard earlier this morning. But a dispute concerning the applicable requirements of due process and whether the respondent has complied with those requirements at every stage is distinct. And that dispute has crystallised. Third, the respondent refers to the fact that the authority proposed consultations. This is an incomplete account of what has occurred. It was the applicants that first proposed consultations. They did so in their notice of dispute of the 18th of May, proposing consultations as a matter of urgency. And as I have explained, the Secretary-General did not adopt or accept that proposal, and instead proposed that consultations be initiated at an appropriate, unspecified time. In any event, a proposal for consultations does not negate or disprove the existence of a dispute. To the contrary, parties commonly propose consultations or negotiations after a dispute has arisen. A final point concerns the scope of the crystallised dispute and the respondent's treatment of the future status of NORI's exploration contract. As you heard from Mr. Wordsworth, to the applicant's genuine surprise, in its letter of the 29th of June, the respondent communicated its position that if NORI's extension application is not approved, the respondent shall treat NORI's contract as no longer in effect from the 22nd of July 2026. On the 1st of July, NORI notified the respondent that this position constitutes an aggravation and extension of the present dispute. Turning now to my second topic, the Chamber has prima facie jurisdiction under Article 187, paragraph C of UNCLOS. Article 187, paragraph C, it's on the screen. It provides that this Chamber has jurisdiction in disputes between parties to a contract, being states parties, the authority or the enterprise, state enterprises, and natural or juridical persons referred to in Article 153, paragraph 2b, concerning 1, the interpretation or application of a relevant contract or a plan of work, or 2, acts or omissions of a party to the contract relating to activities in the area and directed to the other party or directly affecting its legitimate interests. And to recall, the question for the Chamber at this stage is whether this provision appears prima facie to afford a basis on which its jurisdiction might be founded. It does. Starting with the requirement in the chapeau, it is common ground that the present dispute is one between parties to a contract, namely the authority and the applicant. The respondent has not disputed that the applicants are juridical persons referred to in Article 153, paragraph 2b. NORI possesses the nationality and is sponsored by Nauru, a state party to UNCLOS. Likewise, TOML possesses the nationality of Tonga and is sponsored by Tonga, another state party to UNCLOS. Moving to the sub-paragraphs under the chapeau, these are alternatives. Each is satisfied in this case. As regards subparagraph 1, the dispute concerns the interpretation and application of the contract in two respects. First, the respondent's obligation to afford fundamental due process throughout its inquiry is an element of its obligation under Section 13.4 to fulfill in good faith its powers and functions under the Convention and the Agreement in accordance with Article 157 of the Convention. It is not necessary for the applicants to allege bad faith, and for the avoidance of any doubt, the Chamber is not being invited to make a finding of bad faith. Second, under Section 27.1, the contracts are governed not only by their own terms, but also by rules of international law not incompatible with the Convention. Such rules of international law include the right to due process. Accordingly, a dispute over whether the authority has afforded due process in the conduct of its inquiry is, on its face, a dispute concerning the interpretation and application of the contract, and that dispute falls within subparagraph 1. I turn to subparagraph 2 of Article 187, paragraph C. This contains 3 requirements. They are that the dispute concerns 1, acts or omissions of a party to the contract, which 2, relate to activities in the area, and which 3, are directed to the other party or directly affect its legitimate interest. The dispute between the parties concerns acts and omissions of one party to the exploration contract, that is, the authority, which are directed to the other party, that is, NORI and TOML. And that satisfies requirements 1 and 3. It is only requirement 2, namely whether the acts or omissions of the authority relate to activities in the area, that is contested between the parties. Pursuant to the broad ordinary meaning of the words relate to, which are not qualified or limited in any way, there must be some connection between the authority's conduct and activities in the area. The respondent contends that the dispute between the parties does not relate to activities in the area, but rather to the authority's exercise of its compliance powers. The authority's attempt to separate these two matters is not credible. The dispute relates to the due process requirements and whether the respondent has complied with those requirements in the course of an inquiry into the applicant's compliance with their contractual obligations in relation to activities in the area. And this should not be controversial. On the respondent's own case, the July 2025 Council decision arises from the authority's, quote, concerns about unilateral activities in the area. In that decision, the Council tasked the Commission with assessing possible non-compliance arising out of direct or indirect actions related to activities in the area. This formulation was then repeated in the Secretary-General's circular of the 15th of January 2026, and each of the contractual obligations referred to in Section 13 and 27 of the standard clauses also relate to activities in the area. Similarly, in the Secretary-General's letter to the applicants of the 16th of March, the applicants were asked to respond to 3 questions posed because they had been identified as requiring specific attention to possible non-compliance that may arise out of direct or indirect actions related to activities in the area. This is all unsurprising, because the authority's mandate specifically concerns activities in the area. Additionally, one wonders whether, on the respondent's position, any dispute arising out of any assessment of a contractor's compliance with any contractual obligation could ever relate to activities in the area. Moreover, An aggravation and extension of the dispute arising from the respondent's position as to the future status of NORI's contract also falls within Article 187, paragraph C, most obviously because this also concerns the interpretation or application of a contract. Pursuant to Section 27(1), as I've explained, the applicable law governing the contract includes not only other rules of international law, but also procedures of the authority. Such procedures include paragraph 16 of the Council's decision relating to the procedures and criteria for extension upon which NORI relies. Turning now to my third topic, the dispute between the parties does not fall within the limitation on jurisdiction in Article 189 of UNCLOS. The text of Article 189 is in the judge's folder at tab 16. The applicants understand that the respondent focuses on the first sentence, which provides that the Chamber shall have no jurisdiction with regard to the exercise by the authority of its discretionary powers in accordance with this part. In no case shall it substitute its discretion for that of the authority. The respondent contends that the present dispute falls within the Article 189 limitation because it concerns the exercise of the authority's discretionary powers under Article 153 of UNCLOS, paragraphs 9 and 10 of the Council's decision of the 21st of July 2025, and Section 10(3) of the contract. This reflects a fundamental misunderstanding of the applicant's case. The applicants accept that the respondent has certain discretionary powers under these provisions. First, pursuant to Article 153, paragraph 5 of UNCLOS, the authority shall have the right to take at any time any measures provided for under this part to ensure compliance with its provisions and the exercise of the functions of control and regulation assigned to the authority thereunder or under any contract. The applicants accept that Article 153, paragraph 5, confers discretion on the authority as to what measures it takes to ensure compliance. But the dispute between the parties does not concern what measures the authority should or should not have taken in the exercise of that discretion. Further, the applicants are not asking the Chamber to scrutinise the merits of the respondent's findings with respect to compliance. To resolve this dispute, the Chamber need only adjudicate on the lawfulness of the process adopted by the respondent. Second, pursuant to the Council's July 2025 decision and Section 10(3) of the contract, taken together, the respondent has a discretionary power to request information and to identify a contractor as requiring specific attention as to possible non-compliance. But the dispute does not require the Chamber to scrutinise or second-guess the merits of the respondent's decision to exercise these discretionary powers by requesting information, identifying the applicants, or making findings, statements, or recommendations with respect to compliance. As I have explained, the Council has instructed the respondent to ensure due process, transparency, and fairness at every stage in the conduct of the inquiry. When exercising its compliance powers, the respondent has no discretion to disapply or disregard these fundamental principles. In other words, the applicability of due process and the requirement to comply with due process are not matters of discretion for the authority. In this sense, it is inaccurate for the respondent to seek to characterize its exercise of the relevant powers as inherently discretionary in nature. In sum, the dispute between the parties does not concern the exercise by the authority of its discretionary powers, nor do the applicants seek to substitute the Chamber's discretion for that of the authority. Likewise, Article 189 is not engaged in relation to the respondents' apparent recent extension and aggravation of this dispute. The future legal status of NORI's contract is a question of law, notably the interpretation and application of paragraph 16 of the Council's procedures and criteria for extension. Moreover, paragraph 16 itself does not confer upon the respondent any discretion to treat the contract as having expired. To the contrary, it expressly states that the contract and all rights and obligations under the contract shall be deemed to be extended until such time as the Council is able to meet and approve the report and recommendations by the Commission in respect of that contract. It is unclear from the respondent's written statement at paragraph 70 whether the respondent also contends that the Chamber lacks prima facie jurisdiction under Article 189 because the present dispute requires it to pronounce on the question of whether any procedure of the authority is in conformity with the Convention, or to declare any such procedure invalid. If that is the respondent's position, there are 2 points in response. First, the requirements of due process are not a procedure of the authority within the meaning of Article 189. The ordinary meaning of the words in their context refers to an official procedure established by the respondent, akin to a specific rule or regulation adopted by the authority, as opposed to due process as a fundamental rule of procedure. As such, prima facie, there is no impediment to the Chamber ruling on the applicable requirements of due process and whether these have been complied with. Second, even if the phrase procedure of the authority does encompass due process requirements, the present claim concerns the application, or rather non-application, of that procedure in conflict with the respondent's obligation to afford due process. That obligation arises both under the contract, including, as I've explained, as an element of the respondent's obligation to act in good faith under Section 13(4), and under the Convention. Accordingly, prima facie, an exception to the limitation on jurisdiction in Article 189 applies. As to an extension and aggravation of the dispute arising from the respondent's position as to the future status of NORI's contract, this is also not excluded from the Chamber's jurisdiction under Article 189. The respondent's non-application of the procedure set out in paragraph 16 of the Council's procedures and criteria for extension would be in conflict with the respondent's obligations under both the contract, including in particular good faith under Section 13(4), and the Convention, including in particular to exercise control over activities in the area in accordance with the rules, regulations, and procedures of the authority. The final issue I will address is the guidance that the travaux préparatoires provide in relation to Article 189. The respondent invokes the drafting history, stating that the provision reflects the desire of the drafters of the Convention to ensure that the Chamber is not engaged in micromanaging of the administration of this part of the Convention, albeit without any citation to the travaux. Pausing here, the applicants are in no way suggesting that the authority should be micromanaged. What they ask is that the authority comply with basic requirements of due process in accordance with the Council's express instruction. Returning to the travaux, Because the ordinary meaning is neither ambiguous nor obscure, nor manifestly absurd or unreasonable in result, it is not necessary to resort to the travaux. But in any event, the travaux in fact confirm the applicant's understanding of Article 189. We have included the relevant extract from the Virginia commentary at tab 12 of the judges' folders. The travaux reveal that from the early stages of the Third Conference on the Law of the Sea, the drafters were concerned that the Chamber should be able to exercise jurisdiction in relation to disputes like the present one. Indeed, at the third session of the conference, Article 58, paragraph 1 of the informal single negotiating text provided that, this is on the screen, any state party to this convention which questions the legality of measures taken by the Council or by any organ of the Council or the Assembly on grounds of a violation of this convention, lack of jurisdiction, infringement of any fundamental rule of procedure or misuse of power may bring the matter before the tribunal. At the sixth session, the chairman of the first committee explained, disputes which relate to the implementation of this part of the convention include legality of measures taken by organs of the authority, lack of jurisdiction, infringement of fundamental rules of procedure, or misuse of power. This kind of dispute may arise amongst the applicants, contractors, and organs of the authority. The nature of this kind of dispute is therefore primarily contractual and administrative. Juridical safeguards for adjudication of disputes arising from a contract or an administrative decision are essential to proper administration and in turn may serve to reduce possible political influence. The present dispute concerning due process is of a contractual and administrative nature. So too is an aggravation or extension of that dispute arising from the respondent's position as to the future status of NORI's contract. Moreover, juridical safeguards for adjudication of the dispute are essential to proper administration. The applicants acknowledge that the express reference to infringement of any fundamental rule of procedure was not retained in the final text of Article 189. But the respondent has not provided any evidence to suggest that this drafting change should be taken to reflect any radical reversal on the position that such matters do come within the Chamber's jurisdiction, or any intention to depart from the scope and rationale outlined by the chairman of the first committee. Rather, it appears that the drafting change reflects a shift in how Article 189 was to be framed. Whereas the draft provision had initially set out the matters relating to the authority over which the Chamber would have jurisdiction, the focus was reversed so that it set out the matters over which there would not be jurisdiction. On the basis, and that's reflected in the title referring to limitations on jurisdiction, on the basis that the infringement of any fundamental rule of procedure was not to be excluded from jurisdiction, it is understandable that the express reference was not retained. To conclude, there can be no doubt that this Chamber has prima facie jurisdiction over the present dispute. Mr. President, members of the Chamber, with many thanks for your kind attention, that concludes my present submission. I ask that you call Mr. Wordsworth back to the podium to address plausibility of rights and real and imminent risk of irreparable harm.
Thank you, sir. I now call Mr. Wordsworth. You have the floor, sir.
Mr. President, members of the Chamber, as Mr. Ochi just indicated, I'll be addressing the remaining two requirements for the prescription of provisional measures: plausibility of rights and real and imminent risk of irreparable prejudice. Turning first to plausibility of rights, pursuant to Article 290, paragraph 1 of UNCLOS, the Chamber may prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties to the dispute. Of course, you know this wording very well. It is uncontroversial that at this provisional measures stage, the Chamber is not called upon to settle the competing claims of the parties or to determine definitively whether the rights claimed by the applicants exist. The Chamber need only determine whether the rights which the applicants seek to protect are plausible. As to whether this threshold is met in the present case, as I said earlier this morning, the purpose of the provisional measures sought is to protect the applicant's right to due process in the consideration of issues of possible non-compliance, rights indeed which the Council has previously recognised. Nevertheless, in its written statement, the respondent asserts that the applicants have failed to demonstrate that their claims encompass any plausible rights. Yet it cannot reasonably be disputed that the applicants do have a plausible right to due process. Indeed, in its written statement, the respondent itself emphasises that the Council's decision of 19th March 2026 expressly requests the Commission to continue to ensure due process, transparency and fairness. And that, of course, is correct. In paragraph 4b of the decision, which you've already been taken to by Ms. Sander, the Council requested the Commission to continue to ensure due process, transparency and fairness at every stage in the conduct of the inquiry. And in its written statement, the respondent correctly characterises this as an instruction to the Commission. Accordingly, the Commission must ensure due process at every stage of the inquiry. Indeed, in her letter to the applicants dated 13th May 2026, the chair of the Commission recalled that the Commission is an organ of the Council and reiterated that the Commission will exercise its functions strictly within the scope of the mandate conferred upon it by the Council and the applicable legal framework. Additionally, Ms. Sander has explained the relevance of the 2024 procedure. There, the respondent has recognised, when assessing possible non-compliance, the need to afford due process, including ensuring a process that is transparent and elicits positive responses. Moreover, in its letters of 16th March 2026, the respondent expressly stated that the 2024 procedure is relevant to the present inquiry. But in any event, noting the express terms of the March 2026 decision of the Council, there is a clearly established right to due process at every stage. The Council's express recognition and instruction to the Commission that the right to due process governs every stage of this inquiry also reflects the fact that the applicants have such a right pursuant to their exploration contracts. To recall, paragraphs 9 and 10 of the July 2025 Council decision involve the Secretary-General requiring contractors to provide information pursuant to section 10.3 of the standard contractual clauses in the exploration contracts. And as to relevant rights and obligations under those contracts, first, as the Chamber has now seen, pursuant to Section 13.4, the authority undertakes to fulfil in good faith its powers and functions under the Convention and the agreement in accordance with Article 157 of the Convention. And as an element of this obligation, the respondent is required to accord due process when exercising its compliance powers. Second, as you have also seen, pursuant to Section 27.1, the exploration contracts, including, of course, the contractor's obligation to submit additional information under Section 10.3, are governed inter alia by rules of international law not incompatible with the Convention. Those rules of international law include general principles of law, which in turn include the right to due process. Consistent with this, in the Tomimaru and in the Virginia G, the Tribunal has recognized that there are international standards of due process of law, and stated in the Louisa case that it holds the view that considerations of due process of law must be applied in all circumstances. Prompt release and a state's adherence to due process is, of course, a different context to that currently before the Chamber. But the different context does not lead to any different result, as is implicitly confirmed by the instruction in the Council's March 2026 decision. Under international law, as under domestic law, due process has legal content. There are international standards of due process, and they are of fundamental importance. In sum, it is indisputable that the applicants have a plausible right to due process at every stage of the inquiry. So on what basis does the respondent say in its written statement that the applicants fail to demonstrate that the applicant's right to due process is plausible in present circumstances? The only reason given is that the Section 10.3 requests are not even arguably incompatible with the Council's instruction to ensure due process at every stage of the inquiry. But that is to focus on only one small aspect of the current dispute, and in any event, incompatibility is a question of breach, which is for the merits. The question at the provisional measures stage is whether the right to due process, for which the applicants seek protection, plausibly exists. There is no additional requirement to establish a prima facie breach. In other words, arguable incompatibility with the applicant's right to due process. Although, as follows from Ms. Sanders' presentation, that is a threshold that the applicants could certainly meet. Finally, on plausibility, insofar as there is now an issue before the Chamber on whether the NORI exploration contract will expire on 22nd July or be deemed to continue until extension is considered by the Council, as provided for by paragraph 16 of its procedures and criteria for extension, the existence of a plausible right could not be in doubt. Of course, NORI has a right to extension as provided for by that paragraph 16. Turning to the further requirements for the prescription of provisional measures, as is well established in the Tribunal's jurisprudence and will be very well known to this Chamber, provisional measures may be prescribed if the urgency of the situation so requires. This implies that there is a real and imminent risk that irreparable prejudice may be caused to the rights of the parties to the dispute. pending the final decision. As the Tribunal has explained, what this requires is determination of 1, whether there is a risk of irreparable prejudice to the rights of the parties to the dispute, and 2, whether such risk is real and imminent. And both of these factors are present in a current case. The risk of irreparable prejudice in the current case arises from the real risk of further steps being taken in the inquiry that are prejudicial to the applicants without the applicants being afforded due process, including the potential making of recommendations regarding non-compliance. The irreparable prejudice to rights in respect of due process is self-evident, and of course, the central claims in the 2 applications that will fall for final determination are that the applicants are not being afforded due process. In its written statement, the respondent advances 3 arguments as to why there would be no irreparable prejudice to the applicants were the Commission to make recommendations. The first argument is that there is nothing to support the applicant's assumption that the Commission will seek to conclude its inquiry process without ensuring due process, transparency and fairness, including providing the right to respond. There are 3 points here. First, the applicant's concern is not only with what will happen when the Commission concludes its inquiry, but with the steps along the way. I recall due process is to be ensured by the Commission at every stage of the inquiry. As explained already, some steps of the inquiry have been planned to be taken. The Commission will present a report and will progress the inquiry. There is also a real risk that the Commission would make recommendations regarding non-compliance. Second, the respondent appears to contend that if it does conclude its inquiry, due process would be accorded in that process, such that there would be no prejudice to the applicants. But that is completely at odds with the respondent's refusal to provide clarifications so far as concerns its letter of 16th March, and its refusal to extend the 31st May deadline to enable the applicants to submit meaningful responses in light of clarified questions. Moreover, the respondent has not explained how the Commission could possibly have accorded due process, including a meaningful right to understand and respond to questions, before the Commission ends its current session on the 10th of July. Third, the applicants are not assuming anything. They are relying on the documents that Ms. Sander has taken you to, which evidence the risk of irreparable prejudice. The respondent's second argument is that even if the applicants are right, the applicants would not be exposed to prejudice in relation to NORI's application for extension of its exploration contract. The point being made was the assertion that consideration of NORI's extension application is a separate and distinct process, and it was said that there is no evidence that the Chamber, or otherwise available, to suggest that the Commission is or has been in any way influenced by NORI's failure to respond to the Section 10.3 requests. In light of the position on extension taken in the respondent's letter of 29th June, it's not clear whether it maintains this line of argument. If it does, as I noted earlier, the basic point is that NORI's contract is due to expire on 22nd of July. And subject to the Chamber's direction under Article 90, paragraph 4, there is nothing to prevent the respondent from rejecting NORI's extension application, although the applicant's position is that this would be impermissible on more than one front. As to the respondent's contention that consideration of NORI's extension application would not be influenced by NORI's failure to respond to the Section 10.3 requests, there are 2 points. First, the harm that NORI faces is not only that the Commission could indeed be influenced by NORI's lack of response to the Commission's 3 questions, the Commission is engaged in its compliance inquiry and has been intending to make recommendations on the inquiry. The Commission is also considering NORI's extension application. There is more in play than an alleged failure to respond to the Commission's questions. Second, if provisional measures are not ordered, there is a real risk that the Commission will be considering NORI's extension application in circumstances where it is simultaneously considering and has likely formulated its recommendations without due process safeguards on whether NORI is complying with the contract. Plainly, the respondent's position on whether NORI is in compliance with its contract may have a material influence on the respondent's consideration of whether that contract should be extended. Indeed, the respondent has publicly stated that it would regard a finding of non-compliance arising from a contractor's unilateral departure from the ISA regime as constituting a serious breach of the trust and legal obligations underpinning its relationship with the ISA, which may affect the contractor's credibility and compliance record across various contexts, including the assessment of future applications. The need for relief to protect the applicant's right to due process is compounded in light of this dual role with respect to compliance, assessment, and contract renewal. In this connection, the Secretary-General has recognised that an inherent conflict of interest exists when the body that approves contracts for exploration and the financial terms thereof is the same body that is responsible for ensuring compliance. The respondent's third argument is that any prejudice that the applicants could suffer is necessarily revenue-based and accordingly not of a nature to be treated as irreparable. But that is incorrect. The prejudice is to the right to due process, which is the right for which protection is sought. In the southern bluefin tuna cases, the tribunal ordered the parties not to take action that might prejudice the carrying out of any decision on the merits. So an obvious question is, what would happen if the Chamber were not to prescribe provisional measures? The authority will continue its inquiry. The authority may find that the applicants are not in compliance with their exploration contracts without affording to the applicants the due process to which they are entitled. How then could the Chamber meaningfully give effect in its final decision to the relief sought in the applications with respect to the requirement of due process being afforded prior to any decision being made on non-compliance? Accordingly, absent provisional measures, there is a real risk that any eventual decision of the Chamber on the merits would be rendered ineffective in practice. The very right of due process that the applicants seek to vindicate could be extinguished before the Chamber has an opportunity to determine whether the process leading to that outcome complied with the requirements of due process. As to the risk of prejudicial steps being real and imminent, the respondent says that the applicants are asking the Chamber to presume that the Commission is about to proceed with its inquiry and produce findings or recommendations. But the applicants presume nothing. They rely on the documents put before the Chamber to show that there is a real and imminent risk. The available evidence strongly indicates that, subject only to the Chamber's direction under Article 90, paragraph 4, the Commission will progress its inquiry into non-compliance before the Chamber makes its final decision on the application. And there is a real risk that it could also make recommendations relating to the inquiry. As explained by Ms. Sander, it now appears clear that the Commission intended to report on this issue and likely make a recommendation during the current session, and the respondent refused to give any assurance that it would not do so. There is now temporary protection due to the Chamber's direction under Article 90, paragraph 4. But that, of course, is only temporary. Absent an order on provisional measures, the risk remains. The Commission may proceed to make recommendations at the intended Part 3 session, and in any event it could convene a session at any time. Moreover, there is no assurance that the Council will not proceed to exercise its powers with respect to compliance, even in the absence of a report and recommendation from the Commission, either at the intended Part 3 session or any other regular or special session it decides to convene. The point raised by the statement in its written statement in no way allays this real and imminent risk. The respondent says that there is no fixed time frame prescribed by paragraph 10 of the 2025 Council decision. But if anything, that supports the applicant's position. The lack of clarity regarding when certain steps will be taken only contributes to the risk that the inquiry could be progressed imminently, as the evidence indicates it will be, and that recommendations could well be made regarding the applicant's compliance with their contracts. And in any event, it can scarcely be denied that there is a real risk that the inquiry will be concluded before the Chamber renders its decision on the merits of the applicant's claims. The respondent also contends that there is a further additional condition for the prescription of provisional measures, being that the measures not cause irreparable prejudice to the rights of the party against whom the measures are sought, that is to say, the rights of the respondent. But the orders that the applicants seek would not cause irreparable prejudice to the respondent's rights. The respondent asserts that the provisional measures sought would heavily circumscribe the conduct of the authority and would make the authority's activities and management unworkable. But that is quite evidently not the case. What the applicants seek by way of provisional measures is, for example, an order that the authority ensure that no recommendations, findings, reports, or other outputs arising from the LTC's inquiry are adopted, issued, published, communicated, or otherwise relied upon pending the final decision of the Chamber. It's entirely unclear how delaying the outputs as a necessary consequence of affording due process could cause any irreparable prejudice to the authority. To the contrary, affording due process will only strengthen the authority and help preserve the integrity of the regulatory framework established under Part 11 of the UNCLOS. Finally, insofar as the respondent is maintaining its position on an inevitable and imminent lapse of the NORI contract, it is obvious that there is a real and imminent risk of irreparable prejudice to the rights of NORI with respect to paragraph 16 of the Council's procedures and criteria for extension. Mr. President, members of the Chamber, I thank you for your attention, and I ask, Mr. President, that you now call Mr. Eastwood to the podium.
Thank you, Mr. Wordsworth. I do now call on Mr. Eastwood to make his statement. Mr. Eastwood, you have the floor.
Mr. President, members of the Chamber, it is an honour to appear before you today on behalf of the applicants NORI and TOML. Over the course of this morning, my colleagues have taken you through the factual background, the legal framework, and the requirements for the prescription of provisional measures. I do not propose to repeat those submissions. Instead, I wish to leave the Chamber with three simple propositions. First, this is a case about due process. Second, the existence of the applicant's right to due process is not seriously opened to question. Third, unless provisional measures are ordered, there is a real risk, if not a likelihood, that this right will be undermined before the Chamber has the opportunity to determine the dispute before it. Before I turn to these propositions, I would like to start with some preliminary remarks on the applicants and these proceedings. It is important not to lose sight of who the applicants are and why the present process has caused such concern. NORI and TOML are not here because they are contractors seeking to find a way to avoid regulatory oversight. They are not contractors with a history of disregard for the authority's rules. To the contrary, they have approached their obligations owed to the authority with seriousness, diligence, and transparency. Their current concerns are heightened because NORI and TOML have a long record of constructive and positive engagement with the authority. For over a decade, they have invested substantially in conducting exploration activities in the area and conducted their activities to a standard that is among the highest of all contractors. For over a decade, they have contributed data, science, operational learning, and institutional knowledge to the authority. This is the result of years of significant investment and efforts in fieldwork, environmental baseline studies, technical development, and engagement with the authority's processes. Together, NORI and TOML have contributed roughly 1/3 of all Clarion Clipperton Zone records held in ISA Deep Data, and more than half of all biological records in the ISA node of UNESCO's Ocean Biodiversity Information System. Those contributions are not merely significant in volume, they also reflect the standard in which NORI and TOML have sought to perform their work. Carefully, transparently, and to an exceptionally high level. They have gone above and beyond in conducting complex operational work, including test mining activities, precisely because they have taken seriously the need to understand environmental, technical, and operational risks related to commercial activities in the area. Against that background, to now find themselves in an inquiry into possible non-compliance, without a clear statement of the case to be answered, without a defined process, and without basic procedural safeguards that the Council itself has required, is profoundly troubling. It goes to the applicant's reputation, their standing as responsible contractors, and the basic fairness of the relationship between a contractor and the authority. The applicants now ask only that the authority's own commitment to due process, transparency, and fairness be honoured before the matters of compliance are decided upon. The applicant's request to this chamber is therefore modest, principled, and deeply practical. Pause the inquiry long enough to ensure that due process is afforded. I will now turn to what this case is about. First, this case is about due process. Throughout these proceedings, the respondent has repeatedly sought to recast the applicant's case as something that it is not. It has been suggested that the applicants seek to prevent the authority from performing its mandate. It has been suggested that the applicants wish to dictate how the authority carries out its compliance functions. It has been asserted that the applicants simply refuse to answer questions. Respectfully, none of these propositions withstand scrutiny. The applicants have never challenged the authority's power to inquire into compliance. They have never contended that the authority cannot request information, nor have they sought to shield themselves from scrutiny. To the contrary, the applicants have repeatedly affirmed their commitment to engage constructively and in good faith with the authority. They responded to the Secretary-General's circular in January. They requested clarification. They sought meetings. They proposed consultations. And even after these proceedings were commenced, they continued to seek practical accommodation. The issue is therefore not whether there should be an inquiry. The issue is how that inquiry is conducted. The applicants say that before they are required to answer allegations of possible non-compliance, and before findings, recommendations, or other adverse conclusions are advanced, they must be given a fair opportunity to understand and state their position on the case they are required to answer. That proposition should not be controversial. It is not radical. It is the very essence of due process. At its core, due process requires that a person affected by an inquiry is not left guessing. It requires transparency. It requires fairness. It requires a meaningful opportunity to respond. And as the Council itself has recognised, it requires those safeguards to be respected at every stage of the inquiry. The second point, that the right asserted by the applicants is plainly plausible, follows naturally from the first. One striking feature of this case is that the respondent has devoted considerable effort to disputing whether it has complied with due process requirements, but it has struggled to explain how it can seriously deny that those requirements exist. The Council's March 2026 decision is, in this regard, of central importance. The Council instructed the Commission to continue to ensure due process, transparency, and fairness at every stage in the conduct of the inquiry, including by providing contractors and sponsoring states with the right to respond. Those are not the applicant's words. They are the authority's own words. The Commission itself has recognised the importance of due process when dealing with contractors identified as being at risk of non-compliance, and has emphasised transparency and the need to elicit positive responses. Indeed, what emerges from the documentary record is a consistent theme. Again and again, the authority's own documents acknowledge that procedures concerning possible non-compliance must be transparent, fair, and conducive to meaningful engagement with contractors. The applicants therefore do not ask the Chamber to create a novel right, nor do they ask the Chamber to adopt an expansive interpretation of the Convention. They ask only that the Chamber preserve a right that the authority itself has expressly recognised. That is why, with respect, the plausibility threshold is so clearly satisfied. I turn to my third and final proposition, that the urgency is real. The respondent says there is no urgency, but urgency must be assessed by reference to realities, not abstractions. The reality is that events are unfolding right now. The Commission's meeting is currently underway. The Council session is imminent. Any suspension of the inquiry has been resisted by the authority. The Council has stated that it awaits the Commission's report and recommendations. The Commission itself has indicated that it will report to the Council during this session. Against that background, the applicant sought straightforward assurances that the inquiry be deferred, that findings, recommendations, or other adverse outputs be withheld pending a fair opportunity to understand the case put to it and then respond. That the authority commit not to advance the process until the due process concerns had been addressed. Those assurances were not given, deadlines were maintained, and this is critically important. The applicants are not required to prove that adverse recommendations will certainly be made. That is not the test. The question is whether there exists a real and imminent risk that prejudice may occur before the Chamber has the opportunity to decide the merits. On the evidence before the Chamber, there can be little doubt that such risk exists. As my colleagues have explained, the applicant's concerns are not theoretical. They arise from developments that are occurring now and which may have consequences before the Chamber has an opportunity to determine the request for provisional measures. In that regard, I would like to make one brief additional observation from NORI's perspective. NORI recently became aware of the authority's position that the President's direction under Article 90, subparagraph 4, will prevent approval of NORI's pending application for an extension of its exploration contract during the current session. NORI is genuinely surprised by and disagrees with that position. As the Chamber has heard, the purpose of the President's direction was to preserve the integrity and effectiveness of these proceedings. It was not intended to place NORI's contractual position in jeopardy while these proceedings remain pending. In NORI's respectful submission, the authority's position rests upon a fundamental misunderstanding both of the effect of the President's direction and of the transitional arrangements applicable to a duly submitted extension application. From NORI's perspective, the concern cannot be overstated. If that interpretation is maintained by the authority, there is a real risk that NORI's contractual position will be adversely affected before the Chamber has ruled on the request for provisional measures. Yet, as NORI has already explained, the applicable framework expressly contemplates the continuation of contractual rights where an extension application has been duly submitted but remains pending within the authority's decision-making processes. NORI therefore sees no basis for the suggestion that NORI's contract would simply lapse because the application has not yet completed its consideration by the authority's organs. Maintaining that interpretation would also risk aggravating and extending the present dispute. Rather than preserving the status quo, pending the Chamber's decision, it would create a further controversy concerning both the proper interpretation of the President's direction and the continuing status of NORI's contract, pending determination of its extension application. From the applicant's perspective, the recent development only reinforces the urgency for the relief sought. In those circumstances, the the applicants respectfully submit that the authority should urgently clarify whether it maintains that position, and if so, identify the legal basis, including how the applicable transitional arrangements governing extension applications could operate so as to place NORI's contractual rights in jeopardy pending completion of the authority's own processes. Turning to why the prejudice is irreparable, the respondent's answer is to say that any harm would be economic. Respectfully, that misunderstands the right at issue. The right the applicant seeks to preserve is not a right to revenue. The right is a procedural right. It is the right to due process. And procedural rights are uniquely vulnerable. Once a process has moved forward without the safeguards that ought to have governed it, it is often impossible to recreate the position that previously existed. One cannot retrospectively participate in a process from which one was excluded. One cannot retrospectively provide a meaningful response before a recommendation has been formulated. One cannot retrospectively enjoy the procedural protections that should have existed before adverse conclusions were reached. That is why provisional measures exist. They are designed to preserve the integrity of proceedings while a court determines the parties' rights. And that is precisely what the applicants seek here. Nothing more, nothing less. It is also important to step back and consider what would happen if the measures sought by the applicants were granted. The authority would retain its powers, the inquiry would remain available to it, the questions could still be answered, the process could continue. The only consequence would be that the authority would first be required to ensure that basic requirements of due process are respected before further substantive steps are taken. By contrast, if provisional measures are refused and the applicants are correct on the merits, the inquiry may proceed in circumstances that permanently deprive them of the very procedural protections they seek to vindicate. To conclude, the current proceedings concern a modest request for provisional measures. The applicants are not asking the Chamber to enter into the question of who is right on the merits. They are not asking the Chamber to determine whether they have complied with their contracts. They are not asking the Chamber to prevent the authority from carrying out its mandate. They ask only that, pending the Chamber's determination of this dispute, the authority not take steps that would render that determination ineffective. The Council has decided and instructed that due process be ensured at every stage. The applicants ask only that those words mean what they say. For the reasons submitted by all four speakers today, the applicants respectfully submit that the conditions for the prescription of provisional measures are satisfied. Accordingly, the applicants request the Chamber to prescribe the provisional measures sought. Mr. President, members of the Chamber, this concludes the applicant's submissions for the first round. I thank you.
Thank you, Mr. Eastwood, for your statement. This brings us to the end of this morning's sitting and concludes the first round of the applicant's oral arguments. The hearing will resume this afternoon at 2:45 p.m. to hear the first round of the authority's oral arguments. The sitting is now closed. Thank you.
All rise. Veuillez vous lever. All rise. Veuillez vous lever.
Please be seated. Thank you. Good afternoon. The Seabed Disputes Chamber will continue its hearing in the cases 34-35. We will now hear the respondents' first round of oral argument. I therefore have the pleasure to give the floor to the agent of the authority, Mr. Dittrich. Sir, you have the floor.
Mr. President, esteemed members of the Seabed Disputes Chamber, it is truly an honor to stand before you today as the agent for the International Seabed Authority. At the outset, may I express the authority's profound respect for this tribunal and for the essential role entrusted to the Seabed Disputes Chamber under Part 11 of the United Nations Convention on the Law of the Sea. This chamber occupies a unique position within the international legal order as the judicial guardian of the legal regime governing the area and its mineral resources, the common heritage of humankind. The International Seabed Authority likewise occupies a unique institutional role created by the Convention and the 1994 agreement relating to the implementation of Part 11. The authority is the organization through which states parties organize and control activities in the area for the benefit of humanity as a whole. The authority exercises regulatory powers that are international in character and must balance diverse and at times competing obligations, such as facilitating activities in the area while ensuring the effective protection of the marine environment, promoting equitable participation by all states, safeguarding the common heritage principle, and administering a legal regime founded upon the rule of law. As with the powers entrusted to it under the Convention, the authority approaches these proceedings with the fullest respect for the legal framework established by the Convention. Throughout its existence, the authority has acted in accordance with the powers conferred upon it by its constituent instruments. Its decisions have been adopted through procedures carefully negotiated by states parties and implemented by organs acting within their respective mandate by consensus. Those actions and decisions are entitled to respect unless demonstrated to be inconsistent with the Convention or other applicable rules of international law. Where the actions and decisions are in exercise of a discretionary power, the Convention, by Article 189, makes clear that they are not subject to review by this chamber. Mr. President, members of the chamber, as we gather here, it is important to reflect on a significant milestone 16 years ago. The Council of the Authority first sought an advisory opinion from this esteemed chamber regarding the responsibilities of states that sponsor entities involved in activities in the area. The late Ni Adunton, at that time Secretary General of the authority, expressed his delight in witnessing small island developing states like Nauru and Tonga taking meaningful steps to sponsor entities for exploration of polymetallic nodules. He believed this symbolized a vital stride towards the realization of our shared vision for the common heritage of mankind. That vision resonates just as strongly today. I am grateful to all of you for your commitment to addressing the first contentious cases ever brought before the Seabed Disputes Chamber. However, it brings us to a point of concern. The very entities that became contractors following the advisory opinion are now challenging the efficacy of the multilateral system within which we all operate and upon which we all depend. As you're all aware, the authority has faced significant challenges over the past year. There is growing apprehension regarding potential unilateral activities in the area, namely the common heritage of humankind, outside the multilateral legal framework established by the Convention and the 1994 implementing agreement. Our Secretary General, Letizia Carvalho, has emphasized that such threats undermine the mandate of the authority and the principles that have guided our work for over 30 years through negotiation and consensus. The role of this chamber is vital in navigating these stormy waters and in safeguarding the multilateral legal framework. The International Tribunal for the Law of the Sea stands as one of the three pivotal institutions established under the Convention, alongside the Authority and the Commission on the Limits of the Continental Shelf. With 172 parties to the Convention, the Authority is the sole entity charged with managing and regulating activities in the area for the benefit of all humankind. Mr. President, members of the Chamber, your decisions regarding the Authority's functions and its obligations, as well as those of contractors, will fundamentally shape the compliance within our mandate and the integrity of the entire Convention. This Chamber understands the gravity of the Authority's mandate and, in its authoritative advisory opinion, paved the way for plans of work to be approved for exploration in areas reserved for developing states. These cases are an attack on measures the Authority has adopted by consensus to ensure that contractors meet their obligations, particularly when potential non-compliance could arise from their activities. It is essential to highlight that discussions surrounding contract extensions fall under the exclusive authority of the Legal and Technical Commission and the Council of the Authority. Importantly, all ongoing inquiries remain just that, ongoing inquiries of a preliminary nature. The Authority invited the applicants to participate in that process at the earliest stage and to have a say whilst respecting confidentiality. No recommendations have been adopted, no decisions have been taken. As I hand over to Council, who will address the applicant's request for provisional measures, I urge you to bear in mind and to take account of the immense significance of your decisions for the authority's work and the profound implications your decisions may hold for our collective future. Thank you. I invite you to call Professor Sands to the podium.
I thank you, Mr. Dittrich. I now invite Mr. Philip Sands to make his statement. You have the floor, sir.
Mr. President, members of the Seabed Disputes Chamber, it's both a great happiness and a privilege to appear before you today on behalf of the International Seabed Authority. Listening to our friends this morning reminded me that a hearing is a bit like a film. I remembered films like Rashomon, Japanese film, and Run Lola Run. You see one story from one perspective, and then you see another story from a different perspective. And you're going to get a very different perspective over the course of the afternoon, because our friends were quite selective in what they shared with you and what they decided not to share with you. So before turning to the very narrow, specific and particular issues that do fall to be determined at this stage of the proceedings, a request for provisional measures, the authority does think it's important to remind the Chamber, and many of you are well aware of this material, we appreciate that, of the wider legal framework that is applicable and the factual context in which these applications have been brought. It is absolutely necessary to keep in mind the rules and obligations on states and parties and contractors under Part 11 of the Convention. And as I said, you only got a tiny part of the story today because the applicants passed in complete silence on what we're about to address. As Mr. Dittrich pointed out, this is the first contentious matter before the Seabed Disputes Chamber under Part 11. But it's not the first time the Chamber has been called upon to consider, interpret and apply Part 11. In February 2011, this Chamber delivered an advisory opinion on responsibilities and obligations of states sponsoring persons and entities with respect to activities in the area. The Chamber received written statements from 12 states parties, 3 organisations and the authority. Oral arguments were then presented by 9 states parties, UNESCO, the IUCN, and again, the authority. Some of us here on both sides of the bar and even on the bench were involved in those proceedings, and you remember them well. In its unanimous opinion, this Chamber acknowledged that the Chamber has the exclusive function of interpreting Part 11 of the Convention and the relevant annexes and regulations that are the legal basis for the organisation and management of activities in the area. The Chamber is given a central role in the interpretation and application of Part 11 and the 1994 Agreement. Article 2 of the latter provides that these 2 instruments, the Convention and the 1994 Agreement, shall be interpreted and applied together in a single instrument, and that in the event of inconsistency, the latter shall prevail. The 2011 advisory opinion recognised that the functions of the Seabed Disputes Chamber are, and I quote, relevant for the good governance of the area, and indeed they are. As put by the authority's then Secretary-General, Ni Oduntun, this Chamber has a high responsibility to ensure that the provisions of Part 11 of the Convention and the 1994 Agreement are implemented properly, and the regime for deep seabed mining as a whole is properly interpreted and applied. In other words, and this is important to recall, Mr. President, as you and the members of the Chamber will be well aware, Part 11 establishes a regime that is sui generis and which must be properly interpreted and applied. The regime is a fundamental element of the Constitution of the Oceans, supported by 171 states and the European Union, all of whom are bound as a matter of law to respect its obligations. They must act in strict accordance with the obligations set forth in Part 11. Now let us not forget the origins of Part 11. It was Arvid Pardo, a most distinguished diplomat, scholar, and professor who made the celebrated address to the General Assembly in November 1967. He called, as you know, for an international regime to address the problem of appropriation for national purposes of the seabed and the ocean floor beyond the geophysical continental shelf. He addressed the issue of the unilateral appropriation of the seabed and ocean floor beyond areas of national jurisdiction. He called for the creation of a special agency with adequate powers to administer, in the interest of mankind, the oceans and ocean floor beyond national jurisdiction. A body that could act not as a sovereign, but as a trustee for all countries. Mr. Pardo imagined an agency endowed with wide powers to regulate, supervise, and control all activities on or under the oceans and the ocean floor. And it is Mr. Pardo from Malta who is credited with the concept of common heritage of mankind, a central and defining pillar of the 1982 Convention and the global legal order. The protection of that pillar is what is in issue in these proceedings, no more and no less. And that document, members of the Chamber, Mr. Pardo's seminal address to the General Assembly in 1967, is in your judges' folder at pages 1 through 18. And it is well worth reading to remind ourselves of what the context really is. The Convention was opened for signature in December 1982. It entered into force in November 1994. And among its provisions, Part 11 brought to life the vision of Arvid Pardo and established the International Seabed Authority. This body is charged with overseeing the international regime and to address the issue of unilateral appropriation. It is endowed with wide powers to regulate, supervise, and control all activities on the seabed, ocean floor, and subsoil thereof, beyond areas of national jurisdiction. Now, against that general backdrop, it is through the lens of the adoption of Part 11 and the establishment of the authority with its exclusive mandate to organise and control activities in the area that these proceedings fall to be understood. What are the key obligations that underpin Part 11, which is a multilateral regime? The beating heart, and I'm going to return to it, is Article 137. And you heard nothing about it this morning from the applicants, and you know why you heard nothing about it. In its 2011 advisory opinion, the Chamber addressed the legal responsibilities and obligations of states parties with respect to the sponsorship of activities in the area. Now, sponsorship is a key element to Part 11. It's a necessary requirement for any contractor to have a sponsor. And in that advisory opinion, this Chamber took great care to describe the interrelationship between the obligations under Part 11, states parties, and contractors. And this is what it said. The purpose of requiring the sponsorship of applicants for contracts for the exploration and exploitation of the resources of the area is to achieve the result that the obligations set out in the Convention, a treaty under international law which binds only states parties thereto, are complied with by entities that are subjects of domestic legal system. This result is obtained through the provision of the authority's regulations that apply to such entities and through the implementation by sponsoring states of their obligations under the Convention and related instruments. Counsel for the authority addressed the Chamber during the oral hearings that led to the 2011 advisory opinion. He explained the manner in which the authority exercises control. As he explained, it is through the binding contracts which are the only basis upon which an entity may carry out activities in the area. I emphasise the words of that counsel who is with us in this room today. the only basis upon which an entity may carry out activities in the area. And he then continued to explain the significance of that exclusive competence. This is a particularly important element when one considers the enforcement provisions found in the standard clauses of contracts, as well as the dispute settlement provisions found in Article 187 of the Convention. Indeed, the contractual nature of the relationship between the authority and those wishing to conduct activities in the area is not only fundamental to, but is a defining characteristic of the legal regime established by the Convention and the Agreement. And in this way, the obligations set forth by the Convention and the 1994 Agreement are binding not just on parties, but also on contractors, and in this case, the applicants, NORI and TOML, which happen to be wholly owned subsidiaries of the metal company. What are these obligations? In its 2011 advisory opinion, this chamber identified two kinds of distinct obligations on sponsoring states, which for the applicants in this case are Nauru, who are with us today, and Tonga, who are not. First, the obligation to ensure compliance by sponsored contractors with the terms of the contract and the obligations set out in the Convention and related instruments. And this chamber concluded that sponsoring states are under an obligation of due diligence, and I quote, to make best possible efforts to secure compliance by the sponsored contractors. And second, the direct obligations with which sponsoring states must comply independently of their obligation to ensure a certain conduct on the part of the sponsored contractors. And of these direct obligations, this chamber explicitly identified, amongst others, the obligation to assist the authority set out in Article 153, paragraph 4 of the Convention. So let's look a little more closely at some of the relevant provisions, and in particular, Article 137 of the Convention, which is directly in issue in this case, on the legal status of the area and its resources. Total silence about this provision this morning and in the written pleadings. Paragraph 1 of Article 137 provides as follows: no state shall claim or exercise sovereignty or sovereign rights over any part of the area or its resources, nor shall any state or natural or juridical person appropriate any part thereof. No such claim or exercise of sovereignty or sovereign rights, nor such appropriation shall be recognized. This is a far-reaching obligation. It extends to all claims by states over or the exercise of sovereignty and sovereign rights in relation to the area as a whole and all of its resources. It prohibits the appropriation of any part of the area and its resources on the part of any state, as well as natural and juridical persons. And it prohibits, without any qualification whatsoever, the recognition of any such acts. Paragraph 2 of Article 137 provides as follows: all rights and the resources of the area are vested in mankind as a whole, on whose behalf the authority shall act. These resources are not subject to alienation. The minerals recovered from the area, however, may only be alienated in accordance with this part and the rules, regulations, and procedures of the authority. And now let's look at paragraph 3. No state or natural or juridical person shall claim, acquire, or exercise rights with respect to the minerals recovered from the area, except in accordance with this part. Otherwise, no such claim, acquisition, or exercise of such rights shall be recognized. That language is crystal clear. No recognition of rights in respect to minerals recovered from the area, except in accordance with Part 11. Let's turn to Article 153 of the Convention, System of Exploration and Exploitation. Paragraph 1 provides that activities in the area shall be organised, carried out, and controlled by the authority on behalf of mankind as a whole in accordance with this article, as well as other relevant provisions of this part, and the relevant annexes and the rules, regulations, and procedures of the authority. Mr. President, I apologise that I'm taking you to materials which you know very well, but they passed in total silence on all of this, and this is really relevant to the proceedings that you currently face. You've understood that. Section 1.1 of the annex to the 1994 agreement provides, and I'm not going to read out the whole thing, the last sentence, the authority shall have such incidental powers consistent with the convention as are implicit in and necessary for the exercise of those powers and functions with respect to activities in the area. And then Article 189, which the applicants have belatedly today finally chosen to address. That deals with the exercise of those powers. You can see it on the screen. You've had it read out to you. I don't need to read it out to you again, but for the purpose of the transcript, let us perhaps treat it as read into the transcript. The authority's exclusive mandate to organise, control and administer activities in the area is also reflected and given effect in the applicant's contracts beyond the convention and the agreement. The applicant's contractual rights are granted expressly in consideration of, I quote, the responsibility of the authority to organise and control activities in the area, particularly with a view to administering the resources of the area in accordance with the legal regime established in Part 11 of the Convention and the Agreement in Part 12 of the Convention, respectively. And then, by virtue of Section 13.1, part of the standard clauses inserted respecting an expiration for polymetallic nodules in the area adopted by the Council, the applicants are obliged to carry out expiration in accordance with the terms and conditions of this contract, the regulations, Part 11 of the Convention, the 1994 Agreement, and other rules of international law not incompatible with the Convention. This undertaking is then further particularised in Section 13.2 of the applicant's contracts, and this provides, among other obligations, the contractor undertakes to comply with the applicable obligations created by the provisions of the Convention, the rules, regulations and procedures of the authority, and the decisions of the relevant organs of the authority, to accept control by the authority, to fulfil its obligations under this contract in good faith, and to observe, as far as reasonably practicable, any recommendations which may be issued from time to time by the Legal and Technical Commission. So they went into their contracts with their eyes wide open. Section 27 then deals with the law applicable to the contracts, and that provides that this contract shall be governed by its terms, the rules and regulations and procedures of the authority, Part 11 of the Convention, the agreement and other rules of international law not incompatible with the Convention. And Section 27.2 obliges the contractor to observe the applicable law and then provides, and the words are important, that it shall not engage in any transaction directly or indirectly, you'll recall the words from this morning, prohibited by the applicable law. You'll begin to see the direction that I am taking. Let me bring the threads together. The combined effect of these provisions, familiar to you, Mr. President and members of the Chamber, admits of no ambiguity whatsoever. They are crystal clear. No one, except for the authority, is entitled to organise, control and carry out activities or to grant exploration licenses with respect to any part of the area and the resources therein. And no one, except for the authority, no state party, no natural person, no juridical person, not the applicants, not their sponsoring states, can claim, acquire, appropriate, or exercise rights with respect to the area except in accordance with Part 11. Nor can they recognise such acts. Let's be clear, Nauru and Tonga are bound by these obligations. So are NORI and TOML bound by these obligations. This is the essential context for understanding what is truly in issue in these proceedings. As Mr. Dietrich has noted, the authority is entitled to have an interest in information about unilateral activities undertaken in the area outside the multilateral framework of the Convention. I don't think that is disputed by the applicants. Indeed, the authority has a legal obligation to act upon such information. So let's look at the information that is in the public domain and that is the source of the origin of these proceedings. And the idea that the applicants were somehow unaware of this, frankly, beggars belief. It is not credible. On July the 27th, 2025, and they've chosen not to share any of the details with you, the US National Oceanic and Atmospheric Administration, the NOAA, received an application from the Metals Company USA LLC, or TMC USA. And let us not forget that NORI and TOML are wholly owned subsidiaries of TMC, like TMC USA. The idea that these are separate companies is a fiction. The application was for a license to conduct seabed mining exploration activities. We've put a copy of the entire document in your judge's folder at pages 21 to 95. We apologise for the length. I'm certainly not going to take you through all of it. But let's have a brief look at the executive summary at page 26 of your judge's folder. It describes the Metals Company USA, duly incorporated under US laws, and then at the end of the first paragraph, submits this application in accordance with the Deep Seabed Hard Mineral Resources Act 1980, and in particular the Deep Seabed Mining Regulations for Exploration Licenses, together known as the Exploration Regulations. Then the next paragraph says TMC USA is registered and domiciled in North Carolina in the USA. Its parent company, the Metals Company Inc., TMC, is a holding company currently domiciled in British Columbia, Canada, and has more than 60% US national shareholders. Along with TMC USA, TMC wholly owns two other subsidiaries, Nauru Ocean Resources Inc., NORI, and TOML. Both NORI and TOML currently hold exploration contracts issued by the International Seabed Authority under ITLOS. TMC, the words are important, TMC USA has entered into intercompany intellectual property and data sharing agreements with TMC's subsidiaries, Nauru Ocean Resources, NORI, Tonga Offshore Mining Limited, TOML, and Deep Green Engineering Limited. You might begin to wonder why none of this was brought to your attention in the course of this morning or in any of the earlier written pleadings. There is then a redaction, not only on this page, but on other parts of the document. And I just want to take you to one other part because it is particularly relevant. Sections 4.5.5 and 4.5.6 of the document, which are also partly redacted. You can see them on screen. I'm sorry it's so small, but you've got the main text in your judge's folder. 4.5.5, use conflict with NORI and TOML confidential. TMC's wholly owned subsidiaries, Nauru Ocean Resource Inc. and Tonga Ocean Minerals Limited, hold exploration contracts issued by the International Seabed Authority. The application area overlaps with a portion of both NORI and TOML's ISA expiration contract areas, see Figure 10. You'll be able to do that in your own time. 4.5.6, Republic of Nauru and Kingdom of Tonga. And this is particularly interesting, also confidential, but this is in the publicly available material. On 4th of June 2025, the Republic of Nauru and NORI announced they had updated their sponsorship agreement. The updated sponsorship agreement considers a TMC subsidiary application via the United States regulatory regime, and specifically Clause 23.14 of the updated sponsorship agreement states, 23.14, save to the extent that the Republic seeks to the Republic, incidentally, is Nauru, seeks to defend its rights or reputation, the Republic will not and will not cause any natural or legal person under the Republic's effective control to take any action or make any statements, whether oral or in writing, in any international or domestic forum which disputes, opposes, obstructs, interferes with, or brings into disrepute, A, any application made by TMC subsidiary to the US for the issuance of an expiration license or commercial recovery permit from the US, or B, any expiration or commercial recovery activity undertaken by TMC subsidiary pursuant to such a license or permit. And it says, TOML and the Kingdom of Tonga are in advanced negotiations on a similar updated sponsorship agreement. And you can begin to understand why they don't talk about this in front of you, because they've got an obligation under this instrument not to say certain things. That's what's going on here. That's the beating heart of this case. Mr. President, members of the Chamber, on its face, and if nothing else, this information in the public domain, readily available on the NOAA website for anyone to see, raises questions about its compatibility with the Convention, in particular, Article 137. I put it no higher than that. Can the authority, in the face of such material, simply pass in silence on what is publicly available? That question answers itself. Very obviously, the authority cannot, and it did not, and it cannot be criticised for that. It did what any reasonable regulator would do. With the full and consensual support of the membership, it initiated an inquiry, simply to ascertain the facts. We heard a lot this morning about where this might go. We don't know where it might go. This is a very preliminary stage to ascertain the facts. And it did what a reasonable regulator would do. It asked the contractors some questions. What is unreasonable about that? What is wrong about that? It put 3 questions to the 2 contractors referred to in the NOAA document, NORI and TOML. It's just the start of a process. It may be a very long process, but it is no more than asking questions to give them an opportunity to explain what they well knew was in the public domain. You heard Mr. Wordsworth this morning mention that when they filled in the form in February 2026, no issues of non-compliance. But they'd already entered into this arrangement. So what is a regulator to do faced with that apparent inconsistency? And I put it no higher than that. As my colleague Mr. Reichold is going to explain shortly, the authority has the power to do exactly what it did, and that is inherently a part of its discretionary powers. Information comes its way which appears to raise an issue, so it asks questions to the contractors while protecting their confidentiality. There is no issue of due process. It's a complete artifice and a construction, the case that has been put to you. A complete artifice and construction. The contractors who appear before you, NORI and TOML, are subject to specific contractual obligations to provide answers to those questions. They signed a contract, submitting themselves to the possibility of such questions. Did they answer the questions? No, they did not. For whatever reason, NORI and TOML, apparently supported at this hearing by Nauru, and there will of course be questions for Nauru, declined to answer the questions. What they did instead was do what commercial litigators do, and you got a full flavour of that this morning. They initiated aggressive legal proceedings, and that's why we are here. And this is the context in which the cases have been brought with the requests for provisional measures. Let me be crystal clear. This is strategic litigation. This is simply intended to delay an inquiry in order to deflect from the responsibilities of the applicants and perhaps also the responsibility of Nauru. It's a delaying tactic, and nothing would make them happier than for you to kick this into the long grass for 2 years while you sort out the merits. That's what they want this tribunal, the chamber, to do. You are being instrumentalized in this process. No more and no less. You're being asked by the applicants to intervene by provisional measures with orders to prevent the authority from fulfilling its obligations and from carrying out its exclusive mandate under Part 11. In the face of information that appears to indicate, at the very least, conduct that raises questions with or compatibility about the provisions that I've just set out, they are asking you to stop the authority and its legal and technical commission in its tracks and not to ascertain the facts. To stop the legal and technical commission, some of you have been on that commission, you know how it functions, from simply asking questions. You're being asked to stop the legal and technical commission at the meeting it is currently sitting in now, in limbo, to not address these matters. You're asked to review the authority's exercise of a manifestly discretionary power to ask questions to a contractor in a manner which we, the authority, say is plainly not permitted by Article 189 of the Convention. The applicants wish to shirk and skirt around their obligations under the Convention, the ones I've taken you to, and in their contracts, the obligation to provide basic information to the authority so that an inquiry can begin. Not concluded, because the authority has made crystal clear the applicants absolutely have due process rights, but at this point, those due process rights have not been violated in any way whatsoever. The only thing that has happened in material terms is a series of questions were put to them. It's that simple. And by way of these claims now and these requests for provisional measures, they've sought the assistance of the dispute settlement chamber, seabed chamber. They have invited you, members of the Seabed Disputes Chamber, each of you, to help them stop the authority from carrying out its task. That's what this case is really about. Now, as the Chamber is aware, the authority's legal and technical commission was due to address the way forward this week. And you'll understand, therefore, why the bringing of these cases has given rise to concern and in some quarters even consternation. And you'll understand, therefore, why the measure adopted last Monday under Article 90, paragraph 4 of the Tribunal's rules, before the authority had a chance to express its views, and which has the effect of preventing the Legal and Technical Commission from proceeding to consider any of these issues before it, frankly, is troubling. The members are sitting in limbo on these issues. Mr. President, members of the Chamber, these are the issues that this group of judges has to confront. And they're now going to be addressed in more specific detail by my colleagues. I ask you to invite Ms. Jones to the podium. I thank you for your kind attention.
Thank you, Mr. Sens. I now invite Ms. Lucy Jones to take the floor. You have the floor.
Mr. President, judges of the Seabed Disputes Chamber, it's a privilege to appear before you on behalf of the International Seabed Authority. I will address the structure and functions of the authority, taking on the baton from Professor Stans, who has just outlined its exclusive mandate under the 1982 Convention, namely, to be solely responsible for the organisation and control of activities in the area on behalf of mankind as a whole. Mr. President, to fulfil this role, the authority is uniquely structured and empowered. It has extensive powers, including those shown before you now in Article 153 of the Convention, referred to by Professor Sands, and I will speak to it again. Subparagraph 1, activities in the area shall be organised, carried out, and controlled by the authority. Subparagraph 4, the authority shall exercise such control over activities in the area as is necessary for the purpose of securing compliance. Finally, subparagraph 5, the very broad, the authority shall have the right to take at any time any measures provided under Part 11 to ensure compliance. My submissions break up into 3 grounds. First, I will outline the key organs of the authority, their respective powers, and their manner of working together. Second, I will address the authority's powers to control and enforce compliance of contractors conducting activities in the area, including, of course, the applicants in this case, NORI and TOML. Third, I will address the authority's inadequate performance procedure, referred to this morning by Ms. Sanders as the 2024 procedure. Respectfully, this document has become a bit of a red herring insofar as it concerns the applicant's request for provisional measures. I will show you the scope and the timeframe that that procedure envisions. Mr. President, if I may, to my first point. As stipulated by Article 1581 of the Convention, the authority has 3 principal organs. Its plenary body, the Assembly, the Council, its executive organ, and a Secretariat, which is responsible for its administration. The Secretariat is ably led by the authority's Secretary-General, who is mandated to perform such other administrative functions as are entrusted to her by the authority's organ. That is a directive emanating from Article 1663 of the Convention. In addition, the principal organs are assisted by subsidiary organs, including the much spoken of Legal and Technical Commission, which is a subsidiary organ of the Council. The Commission's functions are well set out in the Convention and shown before you. Here is Article 165, which shows the powers of the Commission, including those to make recommendations with regard to the exercise of the authority's functions upon request of the Council. That's subparagraph 2A. And C, to supervise, upon request of the Council, activities in the area, where appropriate, in consultation and collaboration with any entity carrying out such activities. Any entity like TOML and NORI. To be clear, Mr. President, the power to make recommendations must be distinguished from the power to make final and binding determinations, and it's important to understand the structure of the organs in this way. That latter power to make binding determination belongs to the Council, and that is who the Commission reports into. In correspondence leading up to these hearings, NORI and TOML have made wide and varied demands of both the Commission and the Secretary-General. For example, in their letters of 21 and 22 May 2026, the applicants demanded that the Commission adopt a quasi-judicial process before posing simple questions to them. Respectfully, it is not as was implied this morning. They have not simply asked for further and better particulars. My colleague, Mr. Reichold, will address this in some detail. I touch on it now because I want to speak to the nature of what the applicants have demanded, why it goes beyond what is feasible, and what they are entitled to as a matter of law. Mr. President, it is key to understand who constitutes the Commission and its ways of working. The Commission is currently composed of 38 members elected by the Council from a pool of qualified candidates nominated by parties to UNITLOS. In common with many other treaty bodies, members of the Commission are international experts with competing responsibilities. They are not employees based at the seat of the authority in Kingston. In fact, they are volunteers. Accordingly and reasonably, their work is mainly carried out when the authority is in session. And that has been referred to many times, and it is simply a shorthand to say the annual meetings of the authority in Kingston. These annual sessions are often divided in 2 or occasionally 3 parts, and as we are all acutely aware, Part 2 of the authority's 31st session began on Monday of this week. It is rare for the Commission to carry out work which requires quorate decision-making out of session, and the reasons for this are pragmatic and easily understood. Members are not based in Kingston, so any intersessional work requiring decision-making must be carried out by virtual meetings, spanning time zones, and accommodating the translation of different languages. This rarely happens. In fact, the only exception is during the COVID-19 pandemic. It is not consistent with the practice of the Commission to suggest that it could or should have addressed the applicant's sundry list of requests and demand at pace and remotely. As stipulated in the 1994 agreement and the Commission's own rules of procedure, decision-making should be by consensus. And what I bring up now is some correspondence for you. This was explained to the applicants in a letter of 13 May by the chair of the Commission. And I'll read a few portions. The work of the Commission is conducted on a collective and consensus-based basis. It would neither be procedurally appropriate nor feasible for me, in my capacity as chair, to express any position on the matters raised in your correspondence, prior essentially to consulting and deciding with her fellow Commission members. The chair then moves to note that she reiterates the Commission's full commitment to the discharge of its responsibilities in accordance with its mandate and established procedures, including respect to all matters duly referred to it by the Council. By its written statement, Nauru doubles down on the applicant's position, flagging the existence of certain informal modalities, virtual exchanges between the Commission and contractors, pursuant to what is known as the snappily titled ISBA 29 LTC 6. As Nauru and the applicants should be aware, these modalities are not comparable to their demands and the work that they are asking the Commission to carry out. These modalities are being carried out to increase the understanding between the parties, that is, the Commission and contractors. They are expressly stated to be informal, and they expressly preclude decision-making by the Commission. I'd like to bring you to paragraph 5E of these modalities. Here you can see the explicit confirmation of these limitations. These exchange of views, these virtual modalities between contractors and the Commission will be informal. Opinions expressed and statements on questions are considered to be informative and should not be interpreted as endorsements or recommendations by the Commission or the Secretariat. All contractors engaging in such an exchange of views will be requested to sign a without prejudice declaration, and that's found at the appendix of this modalities document. Now, from the record, you will be aware, and there was some speak of it this morning, that the applicants have been offered consultations. It's on this similar basis that they were offered. For example, on the 22nd of June 2026, the Secretary-General wrote to the applicants inviting virtual consultations between 29 and 30 June on a without prejudice basis. This was rejected by a letter from the applicants dated 23rd June 2026. Mr. President, if I may, I will move to my second ground, which is to speak to the authority's control of mining in the area. I've already touched upon the broad powers in Article 153, and I'll just quickly set before you again a few more relevant provisions. So the first is the very broad here in the 1994 agreement, Annex Section 1.1, which provides the authority with incidental powers, implicit in and necessary for the exercise of powers and functions with respect to activities in the area. Similarly, Section 152, subpara 2, provides that the authorities shall have such incidental powers as are implicit in and necessary for the exercise of those powers and functions with respect to activities in the area. And finally, the Council very specifically is empowered by Article 162, subpara 1, to exercise control over activities in the area. In addition, as Professor Sands has already touched on, contractors are bound by the clauses in their contracts. There's a standard set of clauses which are incorporated into all contracts, and they're set out in regulations which have been developed by the authority. The relegations relevant in these proceedings are those concerning polymetallic nodules in the area. And the standard clauses which you must consider are 10, 13, and 27. These provide for reporting requirements, which, as you've heard, includes the submission of annual reports, but also such additional information to supplement the reports as the Secretary-General may from time to time reasonably require. Second, these standard clauses contain some undertakings which the contractors agree to. It's to carry out exploration in line with the Convention, the 1994 agreement, and also to accept the authority's control over activities in the area. Finally, Section 27.2 is of key importance to these proceedings. The contracts are governed by the Convention, the agreement, and importantly, that applies broadly. The contractors, its employees, subcontractors, agents, and all other persons engaged or working or acting for them in the conduct of their operations shall observe the applicable law. And that includes, and they have signed up to, not engage in any transaction directly or indirectly prohibited by the applicable law. Mr. President, these obligations and the structures and powers of the authority uniquely empower and facilitate it to control activities in the area. The applicants, NORI and TOML, like all contractors, have agreed to this. Their obligation to provide additional information pursuant to Section 10 has been glaringly avoided, and my colleague, Mr. Reichel, will address you fully on this point. Finally, Mr. President, I need to address you on what has become somewhat a red herring in these proceedings, and that is the Commission's inadequate performance procedure, or as the applicants refer to it, the 2024 procedure. The history to this is as follows. This came around in 2022 when the Council requested that the Commission take the step of annually naming contractors that had essentially responded inadequately to calls from the Council to address issues of concern. The Commission, as a subsidiary organ, responded and issued these criteria, which have become much ado in these proceedings, to address the responses of contractors with the express aim of naming contractors, that is, by company name, that had responded inadequately in the next reporting period. It's important to take a look at this criteria. Paragraph 2 expressly sets the scope of the criteria, and that is, this particular procedure is undertaken for each contractor that has received a notification in relation to contractual obligations arising from the review of its annual report. The Commission assesses only specific contractual obligations on which concerns were identified by the Commission and communicated by the Secretary-General. In addition, this procedure has a very set timeline. Where the procedure applies, a three-step process unfolds, beginning, as you'll see there in step 1, with the Commission's review of a contractor's annual report, and then eventually, in the event that the responses or comments from the contractor remain unsatisfactory, the Commission and the Secretary-General are expressly entitled to report the contractors' names to the Council. As you'll see from this appendix, this three-step process ranges over 1 calendar year, with steps taking place in 2 sessions of the authority. Respectfully, it is obvious that this is not directly the procedure by which the 3 questions were put to the applicants on 16 March 2026. These questions do not arise on the basis of NORI and TOML's annual reports, and it doesn't follow this timeframe. It's also clear and important that the existence of this procedure, applied over a fixed timeframe and applicable to all contractors, does not preclude the authority from carrying out its compliance function and exercising its powers more generally. That would be an absurd result. Mr. President, I'm very grateful for your time. Having now set the stage and outlined the authority's broad compliance powers, I kindly ask you to ask my colleague, Mr. Reichold, to the platform.
I thank you, Ms. Jones, and I now give the floor to Mr. Remy Reichold. Sir, you have the floor.
Mr. President, members of the Seabed Disputes Chamber, it's an honour to take the floor today and do so on behalf of the authority. I will address the pertinent facts of these cases and the events that have led us here to Hamburg. These have left the authority, and more specifically, its Legal and Technical Commission, in a situation of limbo, unable to fulfill its mandate and its compliance functions under the Convention. The applicants, NORI and TOML, both hold contracts concluded with the authority for exploration in the Clarion-Clipperton zone. And if that name sounds familiar, Mr. President, that is because, as you were shown by Professor Sands, it is part of the area covered by the application made by the Metals Company to the US National Oceanic and Atmospheric Administration, the NOAA. NORI is sponsored by the Republic of Nauru, from whom we will hear later. TOML is sponsored by the Kingdom of Tonga. Tonga is not in attendance. And both Nauru and Tonga are members of the authority's council. Professor Sands, a little earlier, summarized the obligations on sponsoring states and contractors and showed you the document on the NOAA website and the references therein to the applicants and their sponsoring states. Bearing in mind the functions and duties and the exclusive mandate of the authority, and in light of the information in that document, the Council, at its 30th session, adopted a decision on the 21st of July 2025. This was a decision adopted by consensus, including Nauru, with no objections. The 2025 decision addresses various matters, including the Secretary-General's engagement with contractors, the annual inadequate performance procedure, which Ms. Jones described to you a few minutes ago and showed you the slide with the time frame, and of course, the 2025 decision also urges sponsoring states to provide information relating to non-compliance by contractors in accordance with Article 139 of the Convention. But of particular relevance, members of the Chamber, for these proceedings are paragraphs 9 and 10 of the 2025 decision, and these are the paragraphs that are now on your screens. Starting at paragraph 9, we see there that the Council, by consensus, requests the Secretary-General, in accordance with section 10.3 of the contractor's contracts, to seek additional information. And there's also reference there to sections 13 and 27 of the contracts. At paragraph 10, the Council urges the Commission, that is the Legal and Technical Commission, by reference to paragraph 9 above, and again in accordance with section 27 of the standard clauses, to pay specific attention to possible non-compliance of contractors, with the obligation that they, their employees, subcontractors, agents, and all persons engaged in or working or acting for them in the conduct of their operations under their contracts shall observe the applicable law. Mr. President, the reason for pausing on this document is because this forms part of the mandate of the Council and the Commission to proceed and ask the questions. It's the 2025 decision, not the 2026 decision, that provides this mandate. Both Professor Sands and Ms. Jones touched on the standard clauses at sections 13 and 27 of the contracts. And these clauses, in essence, give effect to the obligation on NORI and TOML to accept control by the authority. In particular, clause 13.2b, we have there the obligation to comply with the obligations created by the provisions of the Convention, the rules, regulations, and procedures of the authority, and the decisions of the relevant organs of the authority, which includes, of course, the Commission and the Council. Subparagraph E is to observe, as far as reasonably practicable, any recommendations which may be issued from time to time by the Commission. Paragraph 9 of the Council's decision, which is back up on your screens, as you can see, refers also specifically to sections 13, sections 27 of the applicant's contracts. But also, at paragraph 9, we have there an express reference. Turning to that section, so this is now clause 10.3 of the applicant's contracts, imposes a very specific obligation. The contractor shall also submit, in addition, such additional information to supplement the reports referred to in sections 10.1 and 10.2 hereof, as the Secretary-General may from time to time reasonably require in order to carry out the authority's functions under the Convention, the regulations, and this contract. And accordingly, on that basis, on the 15th of January 2026, the Secretary-General sent a circular to all contractors. And thereafter, during the authority's 31st session, in the first part, in February of this year, the Commission provided an update on its implementation of the 2025 decision. The Commission noted that responses had been received from all 21 contractors, but specifically with respect to paragraph 10 of the Council's 2025 decision, the Commission stated that it had identified 2 contractors, neither of whom were named in the Commission's report, as requiring specific attention for possible non-compliance. And it's as a result of that, Mr. President, members of the Tribunal, that the authority's Secretary-General wrote privately to both contractors, to each of them, and asked the questions. And this is what that letter states. So starting at the top, the Secretary-General writes, as per paragraph 10, and this is paragraph 10 of the Council's 2025 decision, the contractor has been identified as requiring specific attention to possible non-compliance that may arise out of direct or indirect actions related to activities in the area, including obligations to act in accordance with the multilateral legal framework established by the Convention and the Agreement. In the light of this paragraph 10, so paragraph 10 of the 2025 decision, the Commission wishes to ask additional information to the contractor on the following issues. And that's what takes us, Mr. President, members of the Chamber, to the 3 questions that have been put to the applicants. They are on your screens. I will not read them out because you have been taken to those questions earlier, but the authority will make 5 observations on this letter and the questions. The first observation, you will note that the Secretary-General has adopted a careful and measured choice of words in this letter, and those words reflect the language of paragraph 10 of the Council's 2025 decision. It is specific attention to possible non-compliance that may arise. In stark contrast to the unhappily contentious nature of this litigation, these questions plainly do not amount to an adversarial process, and nor are they inherently or inevitably prejudicial. On the basis of the language and tone adopted in the applicant's pleadings, one might imagine that the authority was conducting something akin to the Spanish Inquisition. Plainly, it is not. The second observation, the Council, the Commission, and the Secretary-General all have the power to ask such questions of a contractor. The decision to ask questions is a discretionary one, and it is covered by Article 189 of the Convention. Ms. Jones took you through some of the powers and functions of the Council and the Commission, including Articles 162 and 165, respectively, and also to Article 166, by which the Secretary-General is empowered to perform administrative functions as entrusted to her by the Council and the Commission. The third observation, the applicants, NORI and TOML, are under a legal obligation to answer these questions. Professor Sands took you to the relevant provisions of the contracts earlier today. For whatever reason, the applicants have declined to answer these 3 questions. and they have in this way failed to comply with their contractual obligations. The fourth observation: contrary to the supposed bemusement they express, the applicants can be in no doubt whatsoever as to why these questions were put to them. You've seen the application made to the NOAA. You will have noted that in their applications, NORI and TOML pass in total silence on the relevant documents and the facts. And in addition to the NOAA application document, the applicant's parent company issued a press release on the 1st of May 2026 celebrating the NOAA's full compliance stamp of approval. But Mr. President, even if there was any doubt, the Secretary General's letter on your screens, on its face, tells the applicants that the possible non-compliance relates to the obligation to act in accordance with the multilateral legal framework established by the Convention and the Agreement. In other words, the obligation to accept the International Seabed Authority as the sole authority with respect to the area, as set forth in Article 137 of the Convention, and to comply with the procedures and decisions of the Council and the Commission. The fifth observation: 3 days after the Secretary-General transmitted these questions to the applicants, the Council, of which both Nauru and Tonga are members, adopted another decision by consensus without objection. In its decision of the 19th of March 2026, the Council expressly supported the Commission's inquiry. That is on your screens now, at paragraph 4. The Council expressed its support for the Commission's intent to continue its inquiry, and it requested the Commission to take the 2 steps at A and B. So the first one was to consider information, and the second is to continue to ensure due process. It is important to look at what the Council actually decided, but also when it was decided. This 2026 decision on your screens came 3 days after the Secretary-General transmitted the questions to the applicants. And it is in that context and against that backdrop that the Council expressed by consensus its support of the inquiry process, which had already started. And that is why the decision sets out very broadly the framework within which the Commission should continue to carry out its work. So first, to consider information obtained from the contractors and from other sources, and B, to continue to ensure due process, transparency and fairness at every stage. Because when those words were adopted, the questions had already been asked. Mr. President, the Commission is not a kangaroo court, as the applicants would have you believe. The Commission's 3 questions are no more than an initial information gathering exercise, a preliminary step intended to ascertain the facts and give the applicants an opportunity to feed into the process at an early stage. They do no more than seek relevant information, no more and no less, and very obviously they express no view on the facts. It's also important to note that even at that point, the authority did not name the applicants. The information about the applicants has only emerged because of these proceedings that they have brought. NORI and TOML are the authors of their own publicity. Moreover, the process was, and still is, at a very early stage, as acknowledged by the Council itself, which in the preamble of the 2026 decision states that identification for specific attention to possible non-compliance is a preliminary step and does not constitute a finding of non-compliance. In addition to this, in its last operative paragraph, the Council adds in its 2026 decision that any additional information provided under this decision shall be treated in accordance with applicable confidentiality rules and without prejudice to any rights under the Convention, the 1994 Agreement, and the rules, regulations, and procedures of the authority. So that takes us then to how did the applicants, NORI and TOML, react to this request for information? Well, in short, not well. They adopted the kind of approach that will be familiar to anyone who's ever been involved in sharp-elbowed commercial litigation. The best form of attack is defense. An attack they did. By letters dated 21 and 22 April 2026, the applicants made a series of demands seeking to dictate precisely how the Commission should carry out its functions. Mr. President, we've put one of the two letters on your screens. This is the one that has come from NORI on the 21st of April, and you'll see we've struggled to put all of these demands on the screen at once. We heard from Mr. Wordsworth this morning that this is not such a big ask. But let us take a look at the ask. First of all, the applicants demanded to be provided with any factual findings and any proposed recommendation to the Council in sufficient time to comment before transmission. But of course, at that point, there were no factual findings. Second, the applicants demanded to be informed of the basis on which they were identified. This, as I've said, they well knew. Third, the applicants wanted complete copies of materials, including documents, data, analyses that were before the Commission when this identification was made. Fourth, they demanded the source of those materials. Fifth, in respect of each of the three questions that were asked, the applicants demanded, first, the specific facts or conduct, relevant time periods, and any documents on which the Commission relies upon, and whether each question concerns actual conduct, planned conduct, or conduct by third parties, and how the Commission proposes to distinguish between contractor-originated data and data provided by or protected by the authority. And they demanded identification of the precise legal basis upon, including the relevant UNCLOS provisions, the authority's rules, regulations, and procedures, and specific contractual clauses that the Commission considers to be engaged, and an explanation as to the connection between those provisions and the applicable law under the applicant's contracts, each of these in relation to the three questions. But the list goes on. Sixth, the applicants demanded from the Commission the definition it applies to appropriation of any part of the area or its resources, and to explain how a data sharing agreement could amount to such appropriation or otherwise be considered outside the multilateral framework. Seventh, they demanded confirmation that any interim views, draft findings, final recommendation will clearly identify the legal provisions relied upon, set out the evidence considered, explain the reasoning linking the factual record to the applicable law. Eighth, the applicants demanded from the Commission an index of the materials on which the Commission intends to rely and disclosure of any material that may be adverse to their position, including relevant public sources. Ninth, the applicants demanded to attend and be heard at the Commission's meeting in Kingston during the current session, which is happening right now, including answering technical and legal questions arising or immediately following the Commission's deliberations. Having summarised these requests, rather than Mr. Wordsworth's description of not a big ask, perhaps a better description is deluge. One interpretation of this deluge is that the applicants were feeling rather defensive. So they tried to turn things around, and on top of everything, they imposed a deadline of less than 3 weeks on the Commission, during a period when they knew the Commission was not in session. That is a litigation strategy. Is it reasonable, Mr. President, to demand that the Commission address all of those questions within 17 days when it is not in session? Is there a right under the Convention, under the 1994 Agreement, in the rules, regulations, procedures of the authority, or under the contracts, for the applicants to impose these demands on the Commission? And can contractors make their compliance with obligations to provide information dependent on such demands? The answers to those questions are no, no, and no. The authority has been patient. It has acted fully within its powers and reasonably in trying to resolve these issues before this hearing. On the 13th of May 2026, the Chair of the Commission wrote to the applicants, and as Ms. Jones showed you, the Chair explained that the Commission's work is on a collective consensus basis, and it would not be procedurally appropriate for the Chair to deal with all of those issues on her own. The Chair explained that they require full and proper consideration and deliberation by the Commission as a whole, and that is why the Chair also reiterated the Commission's full commitment to discharge its responsibilities in accordance with its mandate and established procedures, including with respect to all matters duly referred to it by the Council. What was the response of the applicants to the letter from the Chair? Well, a few days later, they sent to the authority notices of dispute under the Convention. That is once more a litigation strategy. But nevertheless, the authority sought to engage with the applicants constructively. And on the 26th of May, 2026, the Secretary-General wrote to the applicants proposing consultations following discussions with the senior leadership of the Commission. And the Secretary-General stressed that the applicants' requests were receiving thoughtful consideration, and that the authority remains committed to fostering a collaborative and amicable solution that serves the best interests of all the parties involved. And the Secretary-General stressed that the authority is dedicated to the peaceful resolution of this matter and to fulfilling its responsibilities in good faith with full respect for the rights and obligations of all the parties under the Convention. Mr. President, members of the Chamber, the authority's position has not changed. Last week, again, the Secretary-General reiterated the authority's invitation to engage in consultation with the applicants and also offered an extension of time to answer the Commission's questions. The applicants have rebuffed the authorities' invitations to engage in constructive dialogue. They have instead pursued an aggressive and premature litigation strategy. They chose to come to the Seabed Disputes Chamber to enlist the support of its judges and to request the prescription of provisional measures. The objective is clear. It is deflection and evasion of obligations under the Convention, and in particular, avoiding answering the questions that were put to them, which are reasonable and necessary. This litigation strategy was chosen as a way of putting the authority on the back foot and to dissuade it from following through on its obligations to oversee compliance with the multilateral framework. Mr. President, those are the facts. They make clear that these requests for the prescription of provisional measures are strategic, without merit, and wholly premature. It is not the rights of the applicants that are in issue. It is the obligations by which they are bound. And to address those points, Mr. President, I would respectfully invite you to ask Professor Sands to return to the podium. But before doing so, Mr. President, we're in your hands, but it now may be an opportune time for the break. Thank you for your attention.
Sir. I do believe that it is the appropriate time for the Chamber to withdraw for 15 minutes and to come back at 4:30. Thank you.
All rise. Veuillez vous lever.
Please be seated. Thank you. Mr. Sands, you have the floor.
You have now heard from my colleagues, Mr. Reichold and Ms. Jones, on the facts, the role granted by the 82 Convention to the authority as custodians of the area, its essential compliance powers and procedures, and the rationale for the rather simple, straightforward, and we say necessary questions put to the applicants on the 16th of March 2026, pursuant to these functions. Now, this sets the factual background for the Chamber's function in addressing the requests for provisional measures. In so doing, it does also raise questions about the role of the Chamber, which of course has a specific and narrowly prescribed function as agreed by the drafters of the 1982 Convention. The drafters, very wisely it might be said, did not give the Chamber the burden of micromanaging decisions to be taken by the authority, and it certainly did not allocate to the Chamber the role of substituting itself for the authority's exercise of discretionary powers. You will not be asked to draft the right questions for the applicants. That is for the authority. Article 189 in this regard is rather clear. Let me turn to the 6 measures requested by the applicants. And in so doing, let us recall that provisional measures are exceptional in character. They exist solely to ensure that the rights of a party in a case, both parties, and I'll come to that, are not undermined pending the determination of the case on the merits. As was remarked long ago in the famous Anglo-Iranian oil arbitration, they may easily be considered a scarcely tolerable interference in the affairs of a sovereign state, or in this case, the authority. I recall too, but it's important to make the point, since it's well established across all international courts and tribunals, in particular ITLOS, that the requirements and conditions for provisional measures to be granted are cumulative in nature. If any one is not met, it's the end of the matter. The applicants request that the Chamber orders the authority to do a number of things. To immediately suspend the inquiry regarding the alleged possible non-compliance of the contractors with their contractual obligations, pending the final decision of the Chamber. I'm just going to ask my colleague, because at this point, that ought to be up on the screen, and there seems to be a problem. So I'm just going to pause for a moment to make sure that is working. It's working. Thank you for your patience. As you can see, this is the request for provisional measures. You're aware of it. They want a number of things: to suspend the inquiry, to refrain from any further steps in relationship to the inquiry, to ensure there are no recommendations, findings, reports, or other outputs from the Commission, not to take any action that could aggravate or extend this dispute, or, as is common with many such applications, to order such other provisional measures as the Chamber considers necessary. And in addition, NORI invites this Chamber to order that pending the final decision of the Chamber to prohibit the authority from taking any step or adopting any position, including through the LTC, that would prejudge, refuse, or otherwise adversely affect NORI's application for an extension. I'll come back briefly to that in due course. Now, by any standard, I think it's clear that these requests are essentially concerned with procedural steps to be taken by or on behalf of the authority. And I think for anyone who's been involved in any provisional measures cases, you'll, I'm sure, agree that these are very far-reaching in their practical effect. What they seek to do, in effect, is to delay an investigation by the authority into matters of non-compliance, and to do so essentially for years. Literally, the applicants are calling on the Chamber to stop the authority from carrying out the compliance function granted to it by the drafters of the 1982 Convention until you've dealt with this case on the merits. Now that, if you accede to that, you've understood what will happen. Your doors will open, and all someone will have to do is bring an application for provisional measures on a case, and they can completely stymie these types of procedural steps by the authority. The scope, actually, I would say, is breathtaking in its reach. The authority and its organs are in effect to be prevented even from posing simple, straightforward questions to a contractor, or from even considering an act of possible non-compliance under a contract. And Mr. Reicholt took you through the support consensually of the Council for the steps that have been taken. You are being asked, in effect, to determine that the Council, acting by consensus, got it wrong. To grant these requests is to destroy the authority's power of control over contractors, to make it entirely ineffective as a working institution, and to put it and its organs into years of limbo. And you're being asked to do this at the very moment when the multilateral framework created by the Convention is at risk. That may not be a coincidence. As I explained in my initial intervention, the Convention and the authority are faced with information of possible activities being taken in the area without the authorization of the authority. If realized, these real and serious threats would erode the exclusive mandate of the authority and undermine the multilateral framework that is the Convention. To accede to the requests is to undermine a mandate which prevents a lawless race to the bottom for resources. In essence, the applicants are asking the Chamber to order the authority to cease its investigation of actions, information on which is publicly available. And as explained in my initial intervention today, the applicants complain that they've been outed by an addendum issued by the Commission in March 2026, which footnotes the information about an expiration application by the Metals Company USA to the US National Oceanic and Atmospheric Administration. That's wrong. The application is publicly available. You've got everything you need on that material, and I refer you in particular to pages 55 to 57 of your folders. On its face, this publicly available material appears to raise direct questions about compliance with the requirements of the Convention, not least Article 137. So what is the authority to do in the face of such public information? May it ask questions? May it investigate? The applicants say, no, it may not. And by the decision issued on Monday, under Article 90, paragraph 4, the LTC can do nothing pending the conclusion of this provisional measures phase, with all that implies for further delay. Against this backdrop, merely by making this request for the prescription of provisional measures, the applicants argue, in essence, they have to stop the authority organs. If given effect, a coach and horses is driven through the powers of the authority. And this means, in practical terms, that all a contractor has to do to bring the authority's exercise of its compliant functions to a grinding halt is to file a case and bring an application for provisional measures to this chamber. Is that really what this chamber wishes to achieve? Does the chamber really want to open the door to a micromanaging of the compliance functions of the authority? Does the chamber really want to accede to a request which effectively allows a contractor to engage in acts that on their face appear possibly to give rise to serious questions of compliance? We say that would be a deeply damaging situation, and it would be a ludicrous outcome. The chamber would effectively be setting itself against the authority, including the council, and all those parties to UNCLOS which support the way the authority has conducted itself. The approach has been entirely consensual to this point. And in this respect, you may wish to ask yourself this question: how many UNCLOS parties have expressed support for the positions adopted by Tonga and Nauru in relation to this matter? Mr. President, the applicant's requests are not only deeply damaging to the effective functioning of the authority's compliance function, but we're going to go further. We're going to say they are basically not arguable. The authority welcomes this opportunity to appear before the Chamber in this first case, but truly it comes to Hamburg in some sense of dismay and confusion as to why we are all gathered here at all. The applicants have no need for any provisional measures, and they know it. They know, as the Chamber surely knows, that the Commission is merely at an early information gathering stage. It is not taking any decisions which could have any binding effects. Is there a precedent anywhere in the world for an international court or tribunal to intervene by way of a provisional measures application to prevent a regulatory authority from gathering information? If there is one, I have not come across it. And I've been in practice before international courts and tribunals for 37 years. And I sit as an arbitrator in investor-state arbitrations. And we get many requests for provisional measures. And I've not seen anything that looks like this: the mere gathering of information in the exercise of a regulatory compliance function, and one that is discretionary in nature. Show us an example of a precedent. You will have heard more silence from the applicants in relation to that issue. And in this case, as you've heard from my colleagues, the Council has expressly committed, before any decision with binding effects is taken, to continue to ensure due process, transparency and fairness at every stage in the conduct of this inquiry, including by providing contractors and sponsoring states with a right to respond. You've seen the letters dated 26th of May and 22nd of June 2026, in which the Authority Secretary-General has offered consultations. Regrettably, and we do regret this, the applicants have refused to engage, and what they've done instead, as Mr. Reicholt made clear, is opt for an adversarial, contentious, litigious route. The strategy is very clear: delay, delay, delay. That's what this is all about. Mr. President, by your decisions, some might think that the Chamber has given legs to this adversarial route, and we're quite sure that that is not your intention. Indeed, the applicants themselves have now recognised that their requests are delaying certain matters in a manner that they now say is not in their interests. But may I be clear? For the authorities, the delays which it and its Commission are now subject to do raise serious concerns about the future functioning of the arrangements set out in the Convention. Many of the parties to UNCLOS, to be frank, are also surprised and concerned by this turn of events. Let me now, against that background, turn to the preconditions for the prescription of provisional measures, which are well known to anyone with experience before international courts and tribunals, and particularly well known to this panel of judges. As many reasonable observers have already articulated, some of them in public places, you will be aware of them, it's plain that the applicant's request fails on all four conditions. The necessary preconditions for a grant of provisional measures are set forth in Article 290 of the Convention. They're well established, they're not in dispute between the parties in these proceedings. Put shortly, to grant the applicant's requests, this tribunal must first satisfy itself that it has prima facie jurisdiction over the applicant's claim under Part 11, Section 5 of the Convention, and that it can exercise that jurisdiction. Second, conclude that the rights alleged by the applicants are at least plausible. Third, find there to be a real and imminent risk of irreparable prejudice to the rights alleged by the applicants, pending the final decision of this chamber. And fourth, conclude that any measure granted, this is important, and they passed again on silence on this, will equally preserve the rights of the authority, including the right to ensure compliance with the Convention. To be clear, the Chamber of the Tribunal is not bound to grant any measure, even if these preconditions are satisfied. Article 290, paragraph 1 states that the Tribunal has the power to prescribe any provisional measures which it considers appropriate under the circumstances to preserve the respective rights of the parties to the dispute. And the use of the expression which it considers appropriate underscores the fact that the decision to grant or refuse a request for provisional measures is one for the discretion of this tribunal, taking into account all the circumstances. The circumstances include, the authority says, the effective functioning of the arrangements for assessing compliance with the requirements of the Convention, both in these two cases and in the future. And we do invite you to turn your minds to the consequences of any order that may emerge. I turn to the first precondition which this chamber must address. Does it have prima facie jurisdiction in these two cases? The applicants seek to found their claims on Article 187, paragraph C, subparagraphs 1 and 2 of the Convention. This provides jurisdiction for the chamber in disputes that concern 1, the interpretation or application of a relevant contract or a plan of work, or 2, acts or omissions of a party to the contract relating to activities in the area and directed to the other party or directly affecting its legitimate interests. But we noted, as I'm sure you did, and they've only finally come to talk about it today, that the original applications failed to make any mention of Article 189 of the Convention. And this provides for crucial limitations which are to be placed on the jurisdiction of this chamber. The language of Article 189 is clear, and it reflects the desire of the drafters of the Convention to ensure that this chamber is not called upon to micromanage the compliance and other work of the authority. First, Article 189 provides that this chamber has no jurisdiction to opine on the authority's exercise of its discretionary powers, and the sending of questions to the applicants was an exercise of discretionary power. Second, this chamber has no jurisdiction to substitute its direct discretion for that of the authority. You can't draft your own questions. And third, this chamber has no jurisdiction to pronounce itself on the question of whether any rules, regulations, and procedures of the authority are in conformity with the Convention or, more broadly, invalid. And in fact, in their application, some of the letters preceding the application, that assertion was made. Mr. President, we say that the preliminary and non-binding acts complained of by the applicants, intended to gather and assess information, fall squarely within these Article 189 carve-outs. Cutting through all the noise you heard this morning, and there was a lot of it, what the applicants have come here to dispute is the authority's exercise of discretionary compliance powers. The decision on whether to ask questions of a contractor in relation to information that may suggest an issue of possible non-compliance with its contractual obligation is, by its very essence, a discretionary power. The content of those questions is also a matter of a discretionary nature for the authority. And in particular, the expressions of discretionary power are to be found in the procedure that is outlined in paragraphs 9 and 10 of the 2025 Council decision to which you have already been taken. You have no jurisdiction, we say, to review those decisions by the Council. This type of dispute on whether or not the authority may ask questions of a contractor is exactly the kind of discretionary power that is taken outside of the Chamber's jurisdiction by the operation of Article 189. And we'll come back a little more tomorrow on some of the articles that have been submitted on Article 189. The drafters of the Convention were wise. They understood, they recognised that it would not be useful or helpful or desirable for this Chamber to become embroiled in the day-to-day exercise of powers allocated to the authority to engage in its compliance functions. That is not a judicial function. Article 189 reflects an allocation of institutional competences, and this Chamber, like the authority, is bound to respect them. The drafters of the Convention recognise that the authority is best placed and best informed and most appropriately structured to make judgment calls on the appropriate exercise of compliance powers, certainly at the investigative phase. And of course, it is an entity which has a membership of a large number of countries, which place constraints on what it can and will do. My colleague, Ms. Jones, has taken you through the various functions of the authority's organs. They were designed specifically for this purpose, and we say they have been well designed and they work well. The Convention grants a spectrum of discretionary powers to the authority. Some are quite broad, like the powers provided under Article 153, paragraph 4, for it to, and I quote, take at any time any measures provided for under Part 11 to ensure compliance. That is a broad power. Others are more narrowly prescribed, such as the Section 10.3 contractual power, flowing from the nodule regulations and used by the Secretary-General to request additional information from contractors. The drafters, we say, were wise to ensure that the Convention did not require the Seabed Disputes Chamber to put itself in the shoes of the authority and opine on the exercise of these powers. And that's why they saw fit to circumvent this issue entirely, and they established the limits of Article 189 in the Convention. We can put it another way. Do each of you wish to allocate to yourselves the role of deciding on a measure provided under Part 11 to ensure compliance? Do each of you wish to determine the questions to put to a contractor where information exists which may give rise to a possible question of compliance? Is that really the role of a judge who sits on this chamber, to decide what questions should be put and when and how in the pursuit of compliance with the Convention? With great respect, merely to put those questions out there is to answer them. They answer themselves. And I can go further. By the same rationale, it's plain that this chamber has no jurisdiction to decide upon the authority's discretionary application of its procedures and criteria for extension. This aspect of NORI's claim is clearly outside the jurisdiction of the tribunal. That said, and we do want to be absolutely clear on this point, the authority recognises that it is not immune to judicial review by this chamber, and that Article 189 does not provide for a blanket exclusion of jurisdiction. There are exceptions contained in Article 189 of the Convention, but none apply to the applicant's cases. While much smoke and mirror is deployed, seen clearly, what the applicants are objecting to is the authority's exercise of discretionary compliance powers, and in particular the questions posed to the applicants pursuant to the procedure adopted in paragraphs 9 and 10 of the 2025 Council decisions. The applicants attempt to argue that there's a conflict between the authority's acts and Section 13.4 of their respective contracts, which provide that the authority will fulfil in good faith its powers and functions under the Convention and the agreement in accordance with Article 157 of the Convention. You heard counsel for the applicants this morning. That has been dropped. There's no allegation of the authority acting in bad faith. And we had said, this was drafted before this morning, that the assertion is completely unarguable and particularly at this preliminary stage of the investigation. You've seen for yourselves what is publicly available in terms of information on the applicant's engagement with the NOAA system. Is this chamber really going to say, against the background of that information in the public domain, that the questions posed by the authority to the applicants somehow go beyond a good faith exercise of powers under the Convention and the agreement? For this chamber to so rule would be extraordinary. It would completely undermine the authority and undermine the role of the authority. It would undermine the Convention and the multilateral system that it establishes, and it would undermine the rule of law. And some say that, in essence, is what the applicants actually seek to do. Having illustrated that the applicant's claims fall within the carve-outs of Article 189 of the Convention, I don't need to go any further, and mindful of the long day accommodated by this tribunal, I will address the applicant's misconceived reliance on Convention Article 187C, paragraph 1 and 2, but only very briefly. First, Article 187C1 provides jurisdiction over disputes concerning the interpretation or application of a relevant contract or a plan of work. As I've already explained, there is no dispute under the relevant contracts. The applicant's assertion that Section 13.4 undertaking of good faith has been breached by the authority, we would have said is unarguable. They've now dropped it. Second, Article 187C, paragraph 2, is limited to provide jurisdiction over disputes concerning activities in the area, a term defined at Article 1.3 as all activities of exploration for and exploitation of the resources of the area. The applicant's compliance complaints do not address activities as defined in the Convention. No, they relate to the authority's exercise of its compliance powers under Part 11 of the Convention and the 1994 Agreement, including the authority's discretionary powers under Article 153 of the Convention and those of the Council pursuant to Article 162 of the Convention. This does not fall within the remit of Article 187, paragraph C, subparagraph 2. Let me move to the second precondition for provisional measures, namely that this chamber must satisfy itself that the rights alleged by the applicants are at least plausible. It may be helpful to remind ourselves of the key acts on the part of the authority which are complained about by the applicants. These are the March 2026 addendum of the Commission, which footnotes a public application by the Metals Company USA to the US National Oceanic and Atmospheric Administration. As I've already explained, the applicants are referenced in this public application, but they are not named in the Commission's addendum. And secondly, the three questions posed to the applicants on March the 16th, 2026, by private letter sent by the Secretary-General of the authority to the applicants. To a lesser extent, NORI also complained of the Commission's deferral of its consideration of its extension application from Part 1 of the 31st session to Part 2. But as explained in the report of the Commission of the 6th of March 2026, there's no great mystery or magic about this or what happened. Pursuant to the procedures and criteria for the extension, the Commission is required to consider applications in the order in which they have been received. NORI's application was the last of the 8 applications under consideration to be received, and it was not entitled to jump the queue. The Commission was not able to address all applications due to time and capacity constraints, and so NORI, together with one other contractor, was carried over to Part 2 of the 31st session, which is currently underway. It is now, however, presented from considering this following the decision made on Monday under Article 9, paragraph 4 of the rules of the Tribunal. As a consequence, NORI's contract is due to expire on the 22nd of July, 2026. The applicants say it will be saved by the transitional measures, which you can see on the screen, contained at paragraph 16 of the procedures and criteria for extension. But it's not so clear. It's the authority's position that this may not be correct, as NORI's contract is due to expire before, not after, the next scheduled meeting of the Legal and Technical Commission, as the language of paragraph 16 provides and makes clear. This provision existed for a different reason than the one that we are now faced with. Since they've raised this morning, we will return to this issue tomorrow in our second round. Against this background, returning to the plausibility of rights, I'm bound to say it's a dizzying range of rights that are invoked in a somewhat desperate pursuit of provisional measures arising from a couple of rather simple acts on behalf of the authority. What this tribunal has to decide is whether these alleged rights have any legal basis and whether they are applicable to the facts. Before delving into each right, we do need to unpack a misunderstanding which the applicants' cases are built upon. Both NORI and TOML cite a criteria and a framework which they say mandates a particular structure to any and all investigations by the authority of possible non-compliance by a contractor. This is a straw man argument. The process to which the applicants refer is known as the inadequate performance procedure, and as my colleague Ms. Jones has explained, that procedure is just one type of compliance monitoring based on the Commission's review of a contractor's annual report, with the particular aim of naming contractors who are found to have performed in a manner that is inadequate. Its existence does not and cannot preclude the authority from exercising distinct compliance functions, as occurs in these two cases. The three questions posed to the applicants on the 16th of March 2026 were made pursuant to the process adopted in paragraphs 9 and 10 of the 2025 Council decision, as you're now well aware. The inadequate performance procedure does not directly apply to these questions, as is obvious from even a cursory glance at this document. As shown at Appendix 1, the inadequate performance procedure ranges over 1 calendar year and is expressly tied to the review of a contractor's annual report. So let me now turn to each of the applicants' cited rights in turn. And I would just interject here that what I am going to say has been somewhat overtaken by events, because you've heard this morning that the applicants basically are now limited to a single complaint about rights being breached, namely due process. But on the basis of the written statement, the applicants did make an allegation of discrimination. We thought in the written statement this was somewhat half-hearted, claiming a breach of Article 152 of the Convention, but failing to specify any basis or grounds for discrimination, and in particular failing to point out any comparator or any lack of objective and reasonable justification to support a discrimination argument. The applicants have been requested to provide information to the Commission to enable it to carry out its functions under paragraphs 9 and 10 of the 2025 Council decision. They are contractually obliged to provide this information under section 10.3 of their contracts. There is no discrimination. Why do we say that? Because the two applicants are plainly distinguished from all other contractors by their own actions. The explicit reference to them in the public applications by the Metals Company USA to the US National Oceanic and Atmospheric Administration indicates that they appear to have been engaged in certain acts which distinguishes them from all other contractors. I've shown you this document, and the relevant extracts are found at pages 55 to 57 of your folders. It is that conduct which has caused the questions to be asked, as we say the applicants well know. If information comes to light that any other contractor has engaged in similar or analogous conduct, then they too would be asked questions. Second, the applicants assert breaches of their right to due process and fair treatment, and this now is what remains of the case. And this complaint appears to stem from a guarantee set out in the Council's decision of 19th of March 2026, which expressly requests the Commission to continue to ensure due process, transparency and fairness, and stipulates that contractors and sponsoring states alike will be provided with the right to respond. There's no plausible argument by the applicants that their rights have been violated or could have been violated in relation to due process. And it is not the case, as I understood Mr. Wordsworth to say this morning, that all you have to point to is the existence of a right. That is not the practice of international courts and tribunals, not in cases in which I have argued, not in cases in which I have sat, not in cases before this International Tribunal for the Law of the Sea. If I heard him correctly, Mr. Wordsworth said that on the plausibility of rights, all you have to do is show the existence of the rights. It's not only correct, but it cannot be correct. You have to show, of course, the existence of certain rights, but you also have to offer some colourable evidence that there exists a plausible basis for concluding that a violation of those rights might occur or might have occurred. As he was addressing you, and I was listening to him with great care, my mind turned to the possibility of examples. The first one that came to me was from my own recent practice. It's in relation to a rather different matter, and I hope you'll forgive me for bringing it up, but it concerns allegations of the act of genocide. And I'd like to refer you, because it's so well written, to a separate opinion of Judge Nolte at the International Court of Justice, who addressed the circumstances in which the ICJ indicated provisional measures in the case brought by Gambia against Myanmar. As he recorded in his separate opinion, not a dissenting opinion, a separate opinion, explaining the court's vote, the court considered and found that the actions of those who orchestrated the attacks on the Rohingya community read as a veritable checklist of genocidal intent. And those reports that he read and that the court read allowed the court to form and recognise an inference that at that provisional measure stage, a genocidal intent was present. And Judge Nolte then writes, and I quote, "Based on this information, the court considered that under the circumstances, the rights of the Rohingya group deriving from Article 2 of the Genocide Convention, as alleged by the Gambia, were plausible." And you'll find that at paragraph 13 of Judge Nolte's separate opinion in the ICJ order of the 26th of January 2024 in South Africa versus Israel. I'll provide the citation. In other words, it's not just the existence of a right that matters, but also some evidence that a violation of those rights is plausible. And that, of course, was what happened, in my experience, before this tribunal in the Libertad case, when I acted for Ghana against Argentina. If you look at paragraph 98 of the Provisional Measures Order, in that case, you will see, and I quote, "Actions taken by the Ghanaian authorities affect the immunity enjoyed by this warship under general international law," end of quote. And that was the basis, correctly, in which the tribunal ordered provisional measures. In this case, by contrast, there is no evidence whatsoever at this preliminary stage that any rights of due process have plausibly been violated. They received questions, they were invited to provide a response, they failed to do so. Instead, they sent a deluge of demands, and having met a response entirely reasonably from the authority that we're not in a position to address those demands, they now say their due process rights have been violated. With great respect, that is a nonsensical claim. How can it be said that the simple and straightforward questions posed to the applicants are incompatible with the Council's instruction or have somehow violated their due process rights? Can it really be argued that the applicants or their sponsoring states, Nauru and Tonga, have been or will be denied their right to respond? Absolutely not. Of course they won't. The authority has repeatedly reassured the applicants that the process under paragraphs 9 and 10 of the 2025 Council decision will be carried out in good faith and with full respect for the applicants' rights under the Convention and their contracts. The third argument that was made is in a claimed breach of Article 13.4 of their contracts, which contains an undertaking by the authority to fulfil in good faith its powers under the Convention and the agreement in accordance with Article 157 of the Convention. We had drafted this before hearing them speak this morning. We simply could not see how any of the acts of the authority stands in breach of this obligation. It simply could not be understood by us how the authority could be said, by posing questions, to have acted not in good faith, and we're glad to see that that claim has fallen by the wayside. Fourth, the applicants then throw the proverbial kitchen sink at their requests, and they broadly allege that they've somehow been subject to unlawful or ultra vires acts by the authority. I think you've now seen for yourselves that that argument is completely unarguable. And there's a fifth and final argument, which again we heard nothing more about this morning. The applicant asserts rights to have its legitimate interests safeguarded. Have you ever heard of a more hopelessly vague assertion than that one? They don't even define what their legitimate interests are. They don't state which of these interests have not been safeguarded by the authority, and they had nothing more to say about it this morning. In short, it seems that they rely now only on alleged violations of due process rights. There are no plausible rights in issue in this case, period. Turn to the third precondition and the sense of false urgency that has been whipped up by the applicant's own actions. This is what has led to our hasty gathering today at great expense. As this tribunal stated in the Zheng He case, the tribunal may prescribe provisional measures under Article 260 if the urgency of the situation so requires. So you have to determine whether there is a risk of irreparable prejudice to the rights of the applicants and whether such risk is real and imminent. And we say, again, it is simply not even arguable that there is any risk or urgency in this case in relation to questions posed. First, as has already been made clear, the authority is only at a preliminary stage. No steps have been taken by the authority that could be said to affect the applicant's rights in any way at all. At this early stage of the procedure, as provided for by paragraphs 9 and 10 of the 2025 Council decision, adopted, I'm going to stress it, by consensus, the only material steps taken by the authority has been to request information from the applicants and to do so by way of a private letter. The applicants are well aware that there is no imminent risk of prejudice to their rights. It's a point on which the authority has been crystal clear. For example, in its March 2026 decision, the Council expressly acknowledged that the identification for specific attention to possible non-compliance, as reflected in the Commission's March 2026 addendum, is a preliminary step and does not constitute a finding of non-compliance. It has also requested the Commission continue to ensure due process, and so on and so forth. In addition, by letters dated 13th of May 2026, the Secretary-General communicated the Commission's full commitment to the discharge of its responsibilities in accordance with its mandate and established procedures, including with respect to all matters duly referred to it by the Council. And finally, and most recently, the authority has proposed consultations and has relayed to the applicants its dedication to fulfilling its responsibilities in good faith with full respect for the rights and obligations of all parties under the Convention. Well, look, the applicants now invite you to proceed on the basis that somehow the Commission will imminently conclude and produce findings or recommendations that are somehow binding on them. There is no evidence before you to support that proposition. It is simply a presumption, an assumption. It's concocted out of thin air. There is no fixed time frame found in paragraphs 9 and 10 of the 2025 Council decision, and there is nothing to support the applicant's assumption that the Commission will somehow complete its inquiry process at Part 2 of the 31st session, or that it will do anything without ensuring due process, transparency and fairness, and providing the applicants and their sponsoring states with the right to respond and more. Second, with respect to NORI's extension application, this was scheduled to be considered as Part 2 of the authority's 31st session. This contract does not expire until the 22nd of July 2026, so NORI activities in the area have not been impeded, and there was no urgency in this regard. In addition, there's no basis, and this is really important, to suggest that the Commission's consideration of NORI's extension application in any manner influenced or was informed by the ongoing inquiry. They're two completely separate processes, and you've got no evidence before you to indicate anything otherwise. They're separate. The processes are entirely separate and governed by the authority's procedures and criteria for extension. Yet, ironically, it is the applicant, by its requests, that has now stopped the process on the extension and given rise to the very difficulty that it now complains about. Nothing to do with anything we've done, it's what they've done that's caused this difficulty. Third and finally, it is, frankly speaking, very challenging to understand what type of prejudice it is that the applicants can claim they face, bearing in mind the repeated guarantees of due process already provided by the authority. To the extent the applicants have held concerns that they could be publicly named by the authority as contractors at risk of possible non-compliance, both NORI and TOML have already opted to make the information and their role public by bringing these proceedings. They brought these proceedings. They're now telling the whole world what is going on, not the authority. Respectfully, the horse that is named publicity has bolted, and it has bolted because of the actions of the applicants, not the authority. As to other forms of prejudice, the applicants are commercial entities with contractual rights to carry out exploration activities in their area. Any prejudice they might hypothetically suffer is necessarily revenue-based, in accordance with well-established principles and practice. That is not irreparable, and it cannot therefore be subject to a provisional measures order. Finally, Mr. President, I move to address the fourth and final precondition which the Chamber must consider and on which the applicants passed again in complete silence: the impact of any measure you may order on the functioning of the authority and on the rights of the authority. As noted by the International Tribunal for the Law of the Sea in the delimitation of the maritime boundary in the Atlantic Ocean, the object of provisional measures is preservation of the respective rights of the parties to the dispute, in the plural. Accordingly, this Chamber must be, and I quote, concerned to safeguard the respective rights which may be adjudged in its judgment on the merits to belong to either party. We have rights. The authority has rights. They are interfering with the authority's rights by bringing these proceedings. So let me conclude, as I began, putting before you the requests of the applicants. They are extensive, they are intrusive, and they are highly prejudicial to the ability of the authority to exercise its compliance functions under the Convention. And it may well be that they have been designed for that purpose. First, in essence, the Chamber is being asked to endorse and facilitate NORI and TOML's refusal to respond to the authority's questions of the 16th of March. Second, the Chamber is being asked to micromanage the compliance role of the authority, inserting itself into the shoes of both the Council and the Commission. That's what the merits phase is essentially going to be about. The applicants ask this Chamber to prohibit the authority from taking, authorising or permitting any further steps or measures in connection with their possible non-compliance. Have you ever come across a more extraordinarily far-reaching request than this one? One that calls for a complete cessation of any consideration of the applicant's conduct and an enforced silence between two organs of the authority, the Council and the Commission. And third, NORI calls upon the Chamber to prohibit the authority from addressing its extension application unless it proceeds with consideration of that application in a lawful and impartial manner. There is no evidence before you that the authority has not done so. It's difficult to avoid the glaring implication. NORI is content for the authority to consider its application, but only if it is minded to grant it. Evidently, the measures sought by the applicants do not stabilise the dispute or preserve the status quo. To the contrary, they invite this Chamber to step into the shoes of the authority, to micromanage its affairs, and to fetter the authority's essential compliance mandate. If this Chamber were to accept the applicant's premise and grant any of the measures sought, that would set an extraordinarily far-reaching precedent. The authority has to be at liberty to apply its discretionary compliance powers. It is the institution which the parties to UNCLOS have determined is best informed and most appropriately structured to make those judgments. That is what is envisioned, that is what is mandated by Article 189 of the Convention. Mr. President, members of the Seabed Disputes Chamber, that brings to a conclusion my submissions on the conditions for granting provisional measures. We say none of the requests are met, none of the conditions are met, and there should be no provisional measures. The request should be rejected in their entirety. Before wrapping up, the authority does have three brief final observations. First, it is important to be clear about what is really going on here. Two contractors to whom the authority has granted authorizations to explore appear to have entered into arrangements with NOAA. On their face, and putting it at their very lowest, those arrangements raise questions of compatibility with the obligation to respect the authority's exclusive role in granting such licenses. You are being asked to prevent the authority from investigating those facts, from putting questions to the contractors, from even considering any aspect of this matter. If the Chamber accedes to that request, you would be putting in issue, undermining the future of Article 137 of the Convention. Second, the President issued a decision to allow Nauru to participate, not only by submitting a written statement, but also to address the Tribunal. We say with the fullest respect that was a rather generous decision, but of course we completely accept it. That said, there is nothing in Nauru's written statement which requires much of a response from us beyond what we have already said in our written statement, which is reaffirmed. You will have noted, with interest, no doubt, that Nauru had nothing to say about the conditions for the granting of provisional measures. and you will have, like the applicants, had nothing to say about the compatibility of its approach with the requirements of Article 137 or Article 189. Nauru is a party to UNCLOS. As such, it is bound to accept that all rights in the resources of the area are vested in mankind as a whole, on whose behalf the authority shall act, and that minerals recovered from the area may only be alienated in accordance with Part 11 of the Convention and the rules, regulations, and procedures of the authority, and that no state or natural or juridical person shall claim, acquire, or exercise rights with respect to minerals recovered from the area, except in accordance with Part 11, and that no such claim, acquisition, or exercise of such rights shall be recognised. Those are the obligations on Nauru and every other party to the UN Convention on the Law of the Sea. And so we look forward shortly to hearing from Nauru as to how its sponsoring of and support for the applicant in these proceedings may be said to be compatible with Article 137. We look forward this afternoon to hearing an explanation of how Clause 23.14 of its updated sponsorship agreement, you'll find that at page 56 of the judge's folder, can be said to be compatible with Article 137 of UNCLOS. Finally, Mr. President, and on a more personal note, may I say that I personally have never before come across an application for a request for provisional measures that a state or international organisation be required to desist from asking questions or otherwise acting in relation to conduct which on its face appears to be inconsistent with its rights and responsibilities under an instrument of international law. In that sense, the request is historic. For this tribunal to accede to the requests would also be historic, but not, one imagines, in a way that would give rise to much comfort over time. The applicants as contractors, we say, are using this tribunal to drive forward agenda. They want to delay a non-compliance investigation. They appear to offer an impression of wishing to undermine, if not destroy, the multilateral framework that is UNCLOS. If this chamber blinks, it will add fuel to that ambition. Mr. President, members of the chamber, the authority has every confidence that on careful reflection it will ensure that the International Tribunal for the Law of the Sea continues, as it has done since its very first case, in which I was privileged to appear, to protect and enhance the well-being of the 1982 Convention. At a time when the rule of law is under very real challenge, the authority expresses the hope that the tribunal will act to promote the rule of law and multilateral arrangements, not to undermine them. I thank you for your kind attention. That brings to a close the first round arguments of the authority. Thank you, sir.
Thank you very much, Mr. Sanders. You said it's bring to an end, this chapter. I would now like to call on Mr. Lionel Ruin Ajimena, Vice President of the Republic of Nauru. Your Excellency, you have the floor.
Mr. President, members members of the Chamber, it is a great honour and privilege to appear before you on behalf of the Republic of Nauru. My name, as you have introduced, is Mr. Lionel Rowanengamia. I'm the Vice President of my country and also the Minister of its Foreign Affairs. Nauru is grateful for the opportunity to participate in these proceedings under Article 191 of the United Nations Conventions on the Law of the Sea, the Convention, and appreciates the Chamber confirming our rights to participate. We believe strongly that our participation as a sponsoring state will assist the Chamber in the discharge of its important judicial function and consideration of the important matter brought to you for your attention. Nauru appears before you today as a state party to the Convention, as a member state of the International Seabed Authority, including its Council and Finance Committee, and most importantly, to present purposes as the sponsoring state of one of the applicants, Nauru Oceans Resources Incorporated, or NORI. That role places Nauru at the intersection of the contractual relationship under scrutiny, the institutional processes of the authority and the obligations imposed on sponsoring states by Part 11 of the Convention. It is precisely because of these responsibilities are engaged that Nauru considers it necessary to assist the Chamber in these proceedings. Mr. President, members of the Chamber, Nauru is a small island development state. It is also a long-standing member of the Chamber, long-standing and proactive participant in the regime governing activities in the area. It played an instrumental role in the proceedings that led to this Chamber's 2011 advisory opinion on the responsibilities and obligations of states with respect to activities in the area. Nauru, therefore, comes before this Chamber with an established and consistent commitment to the integrity of the Convention, including Part 11, in which Article 137 is located, the 1994 Implementing Agreement. Nauru will structure its submissions in 4 parts. First, I will address the central issue in these proceedings, namely the requirements of due process in the context of the authority's ongoing inquiry into NORI. Second, I will turn to the conduct of the respondent, tracing the sequence of events and interactions between Nauru and the respondent in the context of the present dispute. Then next, I will address why, from Nauru's perspective, the prescription of provisional measures by this Chamber is appropriate and necessary under Article 290 of the Convention. And finally, I will offer brief closing remarks and present Nauru's submissions. I address first the central issue in these proceedings. The central issue concerns the authority's failure to afford due process to NORI in the context of the authority's inquiry into whether NORI has complied with its contractual obligations. For Nauru, the issue is practical. Nauru must be able to understand and assess the authority's concerns, to engage with its contractor, and to ensure compliance in an informed way. Yet, it has been required to engage without being given the information necessary to do so properly. The present proceedings are not concerned with the merits of the inquiry. Rather, they concern whether or not the inquiry adheres to fundamental elements of due process. The respondent's prematurity objection misunderstands the right invoked. Nauru and NORI do not ask the Chamber to decide the merits of compliance. They ask to preserve the procedural conditions necessary for that inquiry to be lawful. A denial of the right to know the case to be met and to be heard at the moment the inquiry is being conducted is not a defect that can be cured after findings or recommendations have been made. Specifically, Nauru submits that due process requires 2 essential elements. First, the contractor and its sponsoring state must be fully informed of the legal and factual basis for both the authority's identification of the contractor as one allegedly of raising concerns for the questions addressed to it. Second, the contractor and the sponsoring state must be afforded a meaningful opportunity to respond before any findings, statements, or recommendations by the authority organs are made. Mr. President, and the requirements of due process are not foreign to the authority's framework. Indeed, they are expressly recognized within it. The Legal and Technical Commission has itself expressly acknowledged that identifying and naming contractors in relation to potential non-compliance raises a key concern of due process. It had accepted that in regard, the process must be neutral, objective, transparent, and timely, and one that elicits positive responses. Those are not aspirations external to the ISA regime. They are legal standards articulated by the authority itself. In furtherance of these principles, the Commission has adopted a structured process, including a three-step approach that is intended to afford due process to contractors being reviewed for compliance concerns. That process is important because it indicates what fairness looks like in this context, notably ensuring a process that presupposes a transparent exchange with respect to concern before any adverse conclusion is reached. The Commission also has a practice of engaging in intersectional exchanges with contractors specifically to facilitate detailed discussions on compliance issues. That past practice is critical in this case. The authority cannot on one hand rely on intersectional practice when seeking information from contractors and sponsoring states, yet reject the possibility of intersectional engagement when clarification is sought from it. The issue is not whether the Commission can work between sessions. Plainly it can, and it has done so, to hold detailed exchanges with contractors. But that capacity has not been used in the present inquiry. Moreover, in the context of this inquiry, the Council of the Authority has expressly directed the Commission to ensure due process, transparency, and fairness at every stage of the inquiry, including by providing contractors and sponsoring states with the right to respond. The importance of due process is heightened in this case because Nauru appears before you as a sponsoring state. Under Article 139, Paragraph 1 of the Convention, state parties have the responsibility to ensure that activities in the area carried out by entities under their sponsorship are conducted in conformity with Part 11. The role of the sponsoring state under Part 11 is not ceremonial. It is a substantive legal responsibility. It links the contractor, the national regulatory framework, and the institutional regime of the authority. Where that relationship is engaged by an inquiry of this kind, due process for the contractor and for the sponsoring state are inextricably linked. As recognized by this Chamber in its 2011 advisory opinion, the obligation under Article 139 extends not only to the Convention itself, but also to the rules, regulations, and procedures of the authority, as well as to contractual arrangements with sponsored contractors. It requires a sponsoring state to exercise effective control and to respond in a timely and informed manner to any indication of potential non-compliance. The discharge of these obligations depends on the flow of information between the authority, the contractor, and the sponsoring state. The Convention contemplates a cooperative system in which sponsoring states are able to obtain relevant information concerning alleged non-compliance, assess it, and where necessary, take corrective measures. Absent that exchange, the sponsoring state is deprived of the very means which it must fulfill its obligations and avoid potential responsibility. It is the absence of information, not the request for provisional measures, that short-circuits the Convention system. A sponsoring state cannot exercise effective control over a contractor in relation to unidentified concerns or undisclosed evidence and unstated criteria. Nauru takes its sponsorship obligations with the utmost seriousness. Nauru has devoted sustained legislative and institutional effort to establishing a sponsorship regime that is coherent, practical, and capable of effective oversight. Its participation in the seabed regime has been consistent and constructive and directed towards the orderly development of the legal framework governing activities in the area. To that end, Nauru has established a comprehensive domestic framework comprising primary legislation, implementing regulations, and a dedicated national authority with responsibility for supervision. It remains among a relatively limited number of state parties to have adopted a fully integrated regime specifically addressing seabed mineral activities. That framework is designed to secure effective control in accordance with the Convention and to give effect to the due diligence standard articulated by this Chamber in its 2011 advisory opinion. Within that framework, oversight is exercised and compliance is monitored, and in that context, NORI has consistently met its contractual and regulatory obligations. Nauru therefore appears before this Chamber as a sponsoring state that has consistently sought in good faith to discharge its responsibilities. That context is relevant. It serves to underline that the present concern is not incidental. It goes to the practical ability of a sponsoring state to fulfill obligations that the Convention places upon it. The authority has not explained why NORI was identified, what factual material gave rise to that selection, or by reference to what legal framework or legal obligation the ensuing questions were framed. Yet, the inquiry has moved forward as though those foundational matters were already understood by all concerned. They were not. The difficulty is not that the Commission asked questions. The difficulty is that it first identified NORI as requiring specific attention for possible non-compliance, and then required NORI and Nauru to respond without identifying the factual material, legal standard, or criteria that justified that selection. It then refused to answer questions posed by NORI and Nauru, seeking to clarify the decision and understand the inquiry process and timelines. Without any clarification or engagement, it is impossible for Nauru to carry out its responsibilities as a sponsoring state. Due process is therefore engaged not by a final sanction, but by the adverse procedural position in which NORI and Nauru have already been placed. The Commission has not provided the legal and factual basis for NORI's identification. It has not explained the evidentiary basis for its concern. At the same time, it has imposed deadlines and required responses. The result is a process in which obligations are engaged, but the information necessary to comply with those obligations is not provided. This directly undermines NORI's participation in the inquiry and Nauru's ability to discharge its obligations under Article 139. The conduct of the respondent reinforces these concerns. It is important to focus on the exchanges between NORI, Nauru, and the authority. Taken individually, each may appear procedural. Taken together, however, they show a consistent pattern. Requests for clarification were denied. Requests to participate to be heard were left unanswered. And yet, deadlines and information demands continue to be pressed, and further consideration during the current ongoing session is imminent. It is that sequence which gives the present dispute its urgency. From the outset, Nauru approached the matter in a constructive and measured way. It did not question the authority's mandate to examine issues of compliance, nor did it seek to impede the work of the Commission. What it sought was clarity as to the legal and factual basis of the concerns said to arise in relation to NORI, so that Nauru could perform its responsibilities as a sponsoring state in an informed and responsible manner. Nauru does not ask the Chamber to prevent regulatory scrutiny. It asks only that scrutiny be conducted on terms the Council itself required, with due process, transparency, fairness, and a right to respond. That position was first put squarely before the Council and directed to the Commission on the 16th of March of this year, 2026. Nauru asked by what criteria contractors have been selected for specific attention, what materials were before the Commission, and what standard or evidentiary threshold had been applied. Those questions went to the fairness and transparency of the process itself. Notably, no member of the Commission was present for the presentation of the chair of the Commission's report, and therefore none of the questions raised by Nauru and other council members were addressed. When no substantive clarification was forthcoming, Nauru followed up by writing on the 17th of April 2026. In that letter, it repeated the questions already raised and explained why the matter could not be treated as a procedural formality. Far from being a premature complaint, as the respondent alleges, as Nauru explained, it required this information in order to understand the steps taken to date and any future steps the Commission may take, so that Nauru can properly discharge its obligations as a sponsoring state under Article 139 of the Convention. In doing so, Nauru also sought clarification as to the source of the information that had led to NORI's apparent identification. That request was especially important because without knowing whether the concern arose from annual reporting or some other material before the Commission or another source altogether, neither NORI nor Nauru could assess the factual basis upon which the inquiry was proceeding. Nauru also requested, pursuant to Rule 53 of the Commission's Rule of Procedure, to attend the Commission's deliberations on this inquiry at the meeting of the Commission in June and July 2026. As a matter particularly affecting Nauru, Nauru explained that it sought to attend not to intrude upon the Commission's work, but to support it, to assist the accuracy of the record, and to ensure that it could discharge its obligations under Part 11 responsibly. NORI likewise sought an opportunity to be heard. Neither request was granted nor received a substantive answer. On the 13th of May 2026, the chair of the Commission responded but did not engage with the substance of the questions raised. Instead, the chair stated that because the Commission was not in session, it could not be procedurally appropriate or feasible to address them. With respect, that did not resolve the difficulty. Nor was that response accompanied by any assurance that the questions raised by Nauru would be addressed before the Commission met or before any further step was taken in the inquiry. The practical consequence was that Nauru and NORI were left to respond to an evolving process without knowing the factual or legal basis on which it had been initiated or having any assurance as to when information would be provided, if ever. The questions relating to processes and timelines were also left unanswered, leaving Nauru and NORI to question how in practice the Council's direction to the Commission to ensure due process, transparency and fairness at every stage of the inquiry, including by providing contractors and sponsoring states with a right to respond, would be met. It also sat uneasily with the Commission's own working methods. As the materials before the Chamber shows, intersessional engagement is by no means foreign to the Commission's practice, including in its exchanges with contractors on compliance matters, and despite what respondents state at paragraph 93 of its written statement. Nauru does not understand why such intersessional engagement could not have at least been explored in this instance. Nauru was therefore left without the clarifications it had sought, without a response to its request to attend, and without any assurance that the requirements of due process, transparency and fairness would in fact be respected at every stage. On the 15th of May 2026, 2 days before the Chair had declined to engage substantively with Nauru's questions, the authority requested additional information from Nauru to be provided within 1 month. Concerning how Nauru intended to ensure that NORI complied with all applicable obligations under the Convention, at what measures it would take to ensure that NORI's exclusive exploration rights remained within the limits of the Convention, and the authority's mandate. Yet that request from the authority was made without first identifying in any concrete way the concerns said to justify it. One cannot reasonably expect a sponsoring state to respond meaningfully to concerns that have not been fully articulated or genuine questions addressed. On the 20th of May 2026, Nauru responded to the chair of the Commission, noting that the procedural matters remained unanswered and that notwithstanding that silence, the deadline imposed on NORI for its responses remained in place. In other words, the process continued to move forward while the information necessary for an informed response had still not been provided. Nauru also recalled that the Council had only recently directed the Commission to ensure due process, transparency and fairness at every stage, including by providing contractors and sponsoring state with a right to respond. Nauru pointed out that to date it had received neither the necessary assurances nor even the courtesy of a response to its request to attend the relevant deliberations. On the 5th of June 2026, Nauru wrote again to the Secretary General of the Authority. Nauru explained that the Commission's determination in respect of NORI directly affects Nauru's rights, interests, and obligations as a sponsoring state. That communication was again constructive effort to engage and to move the process into a sound procedural footing. Nauru emphasizes that its relationship with the authority is essential, and it cannot respond meaningfully to concerns that have not been clearly identified. Put simply, the authority should not enable nor hinder the sponsoring state's ability to perform its duties. Finally, and with Nauru's utmost concern, when these proceedings began, the authorities sought to prevent Nauru's participation in them. Contrary to what is asserted in the respondent's statement, there was no basis in the Convention on the Rules of the Tribunal for the limitations the authority sought to impose. But the more fundamental point is one of principle. The authority's position is difficult to reconcile with the reality that Nauru has repeatedly engaged the authority on these very issues, that its own legal interests and responsibilities are centrally and directly implicated by the inquiry into its sponsored contractor, and that an attempt to curtail its participation sits uneasily with the cooperative and transparent functioning of the Part 11 system. Mr. President and members of the Chamber, the significance lies in the overall picture. At every stage, Nauru acted in good faith, seeking information and fair engagement, but was not given a clear explanation or a real opportunity to respond. For that reason, Nauru seeks provisional measures not to hinder the authority, but to preserve a process that is fair and workable. I now turn to the requirements of the indication of provisional measures under Article 290, paragraph 1 of the Convention. That provision empowers the Chamber to prescribe such measures as it considers appropriate to preserve the respective rights of the parties. The object of such measures is preservative. They are directed not to a final resolution of the dispute, but to safeguarding rights from serious prejudice pending the final decision. That is exactly the function Nauru invites the Chamber to perform here. The jurisprudence of the Tribunal establishes three conditions: prima facie jurisdiction, plausibility of rights, and a real and imminent risk of irreparable damage or prejudice. Nauru addresses these conditions from its own standpoint as a sponsoring state, whose interests and obligations are directly affected by the way in which the authority's inquiry is being conducted. The Chamber has prima facie jurisdiction under Article 181, paragraph C, including subparagraphs 1 and 2, which concern disputes relating to the interpretation or application of contracts and acts of the authority. The present dispute concerns the conduct of the authority in the exercise of these functions under Part 11, and more specifically, the observance of due process in the ongoing inquiry into NORI. In Nauru's submission, that is sufficient at this stage to establish the Chamber's prima facie jurisdiction. The due process rights are well established and arise from the Convention, the rules regulations, and procedures of the authority, the exploration contract between NORI and the authority, and the Council's own decision. The observance of these rights is also indispensable to the proper performance of the sponsoring state's obligation under Article 139. Nauru submits that NORI's rights are more than plausible. They are well established and are directly reflected in the authority's applicable legal framework. Mr. President, before turning to the question of irreparable prejudice and urgency, Nauru wishes briefly to address a recent development of which it has become aware through correspondence exchanged between the parties concerning the President's direction under Article 90, Clause 4 of the rules. Nauru understands that the authority has taken the surprising position that the direction prevents approval of NORI's application for an extension of its exploration contract during the current session, and that, if the application is not approved, NORI's contract will expire on the 22nd of July of 2026. Nauru respectfully does not share that understanding. As Nauru understands the applicable legal framework, where an application for an extension has been duly submitted, but the Commission's report and recommendations have not been considered and approved by the Council, paragraph 16 of the Council decision ISBA-21/C/19 provides for the contract, together with the rights and obligations arising under it, to be deemed extended pending completion of that process. Nauru therefore sees no basis for the proposition that NORI's contract would simply expire merely because the application has not been considered or approved during the present session. The matter is of particular concern to Nauru because any contrary interpretation could cause significant prejudice to Nauru-sponsored contractor and in turn to Nauru's own rights, interests and responsibilities as a sponsoring state under Part 11 of the Convention. Nauru therefore respectfully records its concern with any interpretation that would adversely affect NORI's pending extension application or contractual rights before the authority processes have run their course in accordance with the applicable legal framework. There is a real and imminent risk of irreparable prejudice. At this very moment, the Commission is in session from the 29th of June to the 10th of July 2026. Should the Commission advance this inquiry or reach conclusions, there is a very real possibility that a determination Commission will have reached without due process having been observed. The risk is not hypothetical. Requests for clarification have gone unanswered. Deadlines have been maintained, but and no assurances have been given, none, that NORI or Nauru will be heard before adverse steps are taken. In those circumstances, the consequence is plain. If the process moves forward, the harm will already have occurred. Procedural rights cannot be restored after the fact. The right to be informed and heard must be exercised at the moment it matters. That is what makes a prejudice irreparable. Once findings are made without due process, the opportunity to respond is lost, and it is lost for good. The injury is therefore not merely the possibility of an unfavorable substantive outcome. It is the loss of the procedural opportunity itself, the opportunity to know the case, to answer it, and to assist the authority before the institutional record is shaped. Nauru respectfully submits that the Chamber should indicate provisional measures. No findings, no statements, no recommendations should be made by the authority until this dispute is resolved. More precisely, Nauru seeks to prevent the authority from making findings, statements, or recommendations concerning NORI's alleged possible non-compliance unless and until NORI and Nauru have been provided with the legal and factual basis of the concerns and the meaningful opportunity to respond. These measures do not prevent the authority from exercising its functions. They require only that the functions be exercised fairly and in a manner workable for the sponsoring state. Under Article 290, Paragraph 1, the Chamber has the power to indicate the measures it considers appropriate. That power is broad and is flexible. Whether in the form requested by NORI or in a modified form, the need is clear. Provisional measures are required to preserve the integrity of the process pending a final decision. Mr. President, members of the Chamber, the measures sought are precise and restrained. They do not insulate NORI from scrutiny. Rather, they ensure that the process moves forward on a proper and lawful footing. This case concerns the integrity of the system, as due process protects both the parties' rights and confidence in the regime. For Nauru, this is particularly important as a sponsoring state, for it must be able to rely on procedural fairness to fulfill its obligations under the Convention. Mr. President, this concludes the oral submission of Nauru. I thank you for your attention, and good afternoon.
I thank you, Your Excellency, for your statement. This brings us to the end of today's sitting. The hearing will resume tomorrow at 10 o'clock for the second round of the oral arguments. The sitting is now closed. Thank you.
All rise, veuillez vous lever.